facing first and third party losses due to data breaches, service interruptions, theft, and other cyber threats. He's a member of the American Bar Association and New York Bar Association. Kevin has been recognized by the best lawyers in America and Super Lawyers Upstate New York for his work in insurance law. Kevin obtained his Juris Doctor from the University at Buffalo School of Law, graduating magna cum laude, and served as editor-in-chief for the Buffalo Law Review. He also obtained his undergraduate degree from Canisius College, graduating summa cum laude. Mr. Szczepanski, you can begin.
All right, thanks so much, Carisha, and thank you, Sarah. It's a pleasure to be here. I'm honored to join my fellow panelists, Liz Midgley and Bridget O'Connell, and Justices Martocci and Nowak. Before I begin, I want to make sure I can share my screen.
Kevin, I was just about to tell you, you should be able to. Thank you.
All right, great. So I'm going to do that. All right. And let me convert this into slideshow format. All right, let's begin. And before we do, I want to share a story with you that just happened in the last 24 hours. I think it sort of sets the table for the practical aspects of cybersecurity and ethics in our virtual ADR world. So those of my friends who know me know that I am really kind of obsessed with watching appellate arguments. And I recommend it, especially to our younger lawyers, watching the Fourth Department oral arguments, the First Department arguments. One of my particular favorites is to listen to the Seventh Circuit arguments. Great practice for getting comfortable with the do's and don'ts of oral argument. Anyway, in the First Department now, argument is virtual. And so you have a screen, much like you see now. So imagine my PowerPoint presentation is the big box where the panel of justices is visible. And to the right of your screen, where you can see some of our participants, are the lawyers that are arguing. Sometimes there are court personnel involved in the virtual argument process. So I took immediate note of the gentleman who was at the very top of the box to the right of the screen. If I'm at the top right, it would be exactly where this gentleman was. And throughout the argument, must have been 3 or 4 arguments at least that I observed, this man was on mute, but he was visible. He was laughing. He was obviously talking with people off screen. He was on the phone. And this is while the arguments in the First Department are going on. So I thought he was court personnel, and because the justices were ignoring him, I thought maybe he was the clerk and we'll just let it go. Well, he wasn't. He was an oral advocate. And when it came time for him to argue, his screen went blank and he said, "Oh, I'm so sorry, Your Honors, I can't get my video to work." And Justice Gish, who I believe is a graduate of UB Law, but Justice Gish was the presiding justice in the First Department. And she said, he tried to go, "Oh, I'm sorry, my video isn't available. May I proceed?" And she said, no, counsel, you're not going to proceed yet because I have a problem with you and I want to explain it. You are not visible now, and that is ironic because you have been visible during every single oral argument this morning. And we could see you talking and laughing and taking phone calls, and you really need to learn how to handle your virtual technology because it's very distracting. And he said, "Oh, I'm so sorry." And if you know Justice Gish, she actually has a pretty good sense of humor. She said, no, your apology is accepted. We're all here to help you get better with your technology. And so he went on with his argument, but it's a good reminder of how the proper use of technology has not only practical applications, because you only get a first chance to make a good first impression, and it also has ethical and cybersecurity obligations as well. And that's what we're going to talk about this morning for the next few minutes. So why is this focus on the ethics of cybersecurity everywhere, but particularly in virtual ADR? Well, we know what's driving us, pardon me, we know what's driving us to virtual communications. After COVID-19 hit in March of 2020, there was an exponential increase in participants on the Zoom platform. It exploded. And of course, that has not changed because we found that Virtual technology makes it more convenient for everyone. I have clients in New York. I'm sure you have clients around the country. And whereas we used to fly to New York and sit down with our clients in person, which we still like to do, haven't been able to, now we can set up a Zoom call or a Teams call or another virtual communication and participate far more quickly and efficiently. And of course, it is far less expensive than the cost of flying to another city, paying for a hotel, and doing it the old-fashioned way. There are benefits to it. I have to tell you, I prefer to talk in person, but increasingly clients, and you know from your experience with COVID, many of our colleagues are still more cautious. We all try to be cautious. And if you could do something virtually, you do it. So that's what's driving us and the pivot to virtual communications. What are we going to talk about today then? We're going to talk about the ground rules first, the rules of professional conduct that apply. I think you'll find that part interesting. We're going to discuss the key takeaways from those ground rules in the RPC and explain how they apply to our own experiences. Then I'm going to turn and talk a little bit about good cyber hygiene, because if you don't have that, trying to be mindful of your ethical obligations in virtual ADR is going to be much more difficult. Then we'll hit on some recommendations for virtual ADR, and we'll close at the time we have by talking about some additional considerations for clients and communications with them. So let's begin with the ground rules. I'm going to touch on these briefly because I think you're going to see reference to these rules in some later presentations. What I find most interesting about the rules of professional conduct as they pertain to cybersecurity is that when I first started looking at this, I looked at the rules and I said, well, competence, communication, and confidentiality. We all know those are important. How do they apply to cybersecurity? I don't know about you, but it wasn't obvious to me that they do. Well, let's talk through that, and I think we'll see why. First, with Rule 1.1, competence. We know that a lawyer has to provide competent representation to a client, and that competence requires the legal knowledge and skill necessary to the representation. Comment 8 to Rule 1.1 makes clear that competence extends to technology, because as lawyers, to maintain our competence, we have to keep abreast of what the benefits and the risks associated with whatever technology we use to provide services. And that, of course, includes Zoom and other modes of virtual communication. Turning next to Rule 1.4, communication. So once you have that competence in the technology that you are going to use, you have to be sure to explain how you're going to use that technology to your client and the benefits and the risks of that technology. We're going to talk a little bit more about how to do that, but it's critically important to know that you have to do it. In the course of your consultation with your client, you need to take note of whatever technology you're going to be using and explain the benefits and the risks. And we're going to add some practical meat to that bone in a little bit. The final rule, of course, is one of the most critical, and that's Rule 1.6, governing the confidentiality of information. We have to make reasonable efforts to prevent the inadvertent or unauthorized disclosure, use of, or unauthorized access to protected information. And if we look at the factors that go into determining what constitutes a reasonable effort, you can see how some of those relate directly to cybersecurity. So I would just highlight a couple of them. So you have the likelihood of disclosure if additional safeguards are not employed. We're going to talk about what safeguards there might be for virtual ADR that you should consider employing, the costs of employing those safeguards, the difficulty of doing so, and very often it's not difficult. And finally, the extent to which the safeguards affect your ability to represent your clients. We're not going to touch on that too much. Some of my co-presenters may later, but I can tell you that in preparing for 2 trials, which is what I've been doing over the course of the last few months, there are unquestionably challenges associated with using virtual technology to prepare. And quite apart from the safeguards, there are considerations that you have to think about in determining whether the use of technology is even feasible or appropriate in doing the work that you need to do to zealously represent your client. So we talked about the rules of competence, communication, and confidentiality. We've touched a little bit on how those rules apply to the ethics of cybersecurity, with particular emphasis on Rule 1.1's competency requirement. So let's turn to the key takeaways. What does all this mean? It means that we have to understand the benefits and the risks of the technology that we're using. We have to disclose them to the client, and we have to obtain the client's informed consent. When, certainly at the beginning, ideally at the beginning of the engagement, but certainly before a new technology is used. So for example, where does the rubber meet the road? Suppose that you know that you have a particular client that is going to require virtual communications in order to further the relationship and the exchange of confidential information. You're going to want to make sure that you've disclosed to the client you're going to be using virtual communications. You want to make sure the client is not sitting at Starbucks, or if it's a matter that should not be known to the client's employer, that the client is in a safe, secure place, ideally at home. You want to make sure the client knows that there's no one else with physical or electronic access to the communication. If you take those steps and have that practical conversation with your client up front, and ideally put some of the benefits and the risks in writing, you're protecting your client and you're protecting yourself. So with those takeaways in mind, I want to turn to some of the basics, because I think that before we talk about the ethics of cybersecurity in virtual communications, we have to talk about good cyber hygiene generally, because if we don't have that, it's going to be very difficult to translate cybersecurity safeguards into the ADR realm. So let's start.
Can I pause you for 1 second?
Oh, sure.
Your slides aren't showing in presentation mode, and you spent a lot of time to prepare them. So I just want to make sure attendees can see them while you're speaking.
Yes, of course. So were they showing at any point in time?
It still shows on the, like I see the slides, but I just see the first slide. It's not in presentation mode.
All right, so thank you for letting me know. I'm just looking for the appropriate pull down to move it into
in the top left where it says from beginning. If you press that, it should start, and then you should be able to fast forward.
So in the that you were on. Right, in the PowerPoint mode as well. Right there. All right, so I have from beginning. Now, can you see me advancing my slides now?
Yes. Yep.
Okay. All right. Sorry about that, folks. And thank you so much for interjecting. I appreciate that. So just to be sure, and I know the materials are available, just to be sure, can you just let me know, can you see page 8 of my PowerPoint now? Key takeaways, a lawyer must.
It's on 11.
It's on 11. Train. That's interesting, because on my screen, it's on 8. Okay. Is it on page? This is going to be.
See, can you see what is highlighted in red? On
I can't.
The left side of the screen?
No, I can't.
Because 8 shows at the top on the left, but what is in highlight in red is 11, and that's what we see big.
All right. So now I suppose you can see 8.
Yes.
All right. And now you can see 9.
Yes.
All right. So the way this is working, I'm going to need, forgive me, folks, I'm to make sure that we're both on the same page, I'm going to need to leave this screen open. So you're going to see the small PowerPoint slides on the left, but that'll make sure that we're coordinated. And please feel free to interject if for some reason that's not working. All right, so I am assuming that I am on page 8, unless you tell me otherwise. And thanks again for letting me know the issue. So we talked about these key takeaways. I'm not going to go back on the slides that I've already discussed. Let's start with where we left off, which is the good cyber hygiene that you need to have in place before you even think about the ethics of cybersecurity in the ADR realm. The first thing you're going to want to do in your firm, if you're a solo practitioner on your own, is you're going to want to have someone help you conduct a cybersecurity risk assessment. It's not terribly difficult, but it's critically important. You need to know, for example, what data you have. Obviously, among the data that you have could be confidential employee information, confidential attorney-client information. You need to answer the question whether you need it. Of course, we need the confidential information that we have for the client relationships that are ongoing today. But we've seen many situations in our practice where our clients are retaining information that they don't have a legal obligation to keep. It's in some cases many years old. And when we've represented our clients in response to ransomware attacks, it's become obvious that's a problem, because the threat actor who is trying to collect a ransom will do what's called a proof of life, showing the client that, yes, indeed, I do have your data, so my threat to expose your data on the internet is real. We've often seen that proof of life data is that data that is many years old. And if the client had just gotten rid of the data and deleted it or destroyed it in the normal course, that data would not have been the subject of the ransomware attack. So very important to know not only what you have, but to think about whether you actually still need it. Where do you keep it? And here we're talking about not only data that's physically stored, but also data that's electronically stored. Is it stored on a server? Do you have a backup outside your server? Do you store your data in the cloud? And once you've answered that question, the most important question becomes, who has access to your data? Does everyone in your firm or organization have access to it? Or do you limit access to only those that absolutely need it? Those are critical things that you need to think about. Once you conduct that cybersecurity assessment, you want to develop and revisit on at least an annual basis a written cybersecurity plan. And that plan should implement reasonable safeguards. I've listed some here. We're not going to walk through every single one of them, but I can tell you from our practice that whatever line of business your client is in, whether it is a small manufacturer or whether it is in a more heavily regulated industry like healthcare or finance, these safeguards that you see are always listed among whatever cybersecurity protocols are implemented by regulatory authorities. In fact, one quick example, the New York DFS, the Department of Financial Services, has implemented Regulation 500, which lays out a list of cybersecurity safeguards that financially regulated industries, including insurance companies, whom I represent, must implement. Recently, a federal regulator implemented its own new set of cybersecurity safeguards. We took a look at them. They are almost word for word what's in the New York DFS. So what we're seeing is regulatory authorities, state and federal, they're not creating new safeguards out of whole cloth. Their safeguards are reflecting what we know to be the industry standards, what we consider to be reasonable for organizations, including law firms. And these safeguards are the ones that we always turn to. You want to make sure that you have not only secure Wi-Fi, so if you're communicating with a client or a client with you, you want to make sure that the client is not sitting at Starbucks or in a public place because that Wi-Fi connection is not secure. You want to make sure that you're using a VPN or a virtual private network so that the communications are protected. I want to quickly talk about multi-factor authentication and why that's important. We just had a client responding to a ransomware attack, and the client was a healthcare provider, but did not have any of these safeguards. And in fact, we were asking the client, do you have multi-factor authentication? Do you have smart passwords? The client poor gentleman he's kind of embarrassed that I don't even know what those things are. So I just want to quickly highlight, multi-factor authentication is not just login and password. Most of you probably know this, but it is an extra step of security beyond just your login and password. Generally, it focuses on who you are, what you have. You may have a token or a PIN or a passcode in addition to your login and regular password, and what you are, meaning your biometric identification may require a fingerprint, for example, or a retina scan. Those of you that have may travel frequently, you may be familiar with CLEAR at the airport. When I go through CLEAR, I bypass all the security, but they do a retina scan to confirm my identity. So the others I just want to highlight on this are the last few. I can't tell you how many times we have clients come to us with cyber incidents, some of which turn into data breaches, and it turns out that the client did not timely implement antivirus software or did not have a patch and update program. And that's critically important because the software providers and the streaming services that we use every day, they are discovering vulnerabilities in their systems all the time. And when they discover those, they implement patches. They let you know that the patches are intended to correct security bugs and other issues. And if you don't implement those patches right away, A, your system is at risk, and B, if something goes wrong and information from your client is exposed, the question could come back to you. Well, Kevin, what did you do? Did you have a patch program? Did you implement all the security fixes? And if my answer to that question is, no, we were late on that. No, we don't have a protocol for doing that, there's a potential issue. And you want to try to avoid that. So these are the reasonable safeguards. Focusing on test and train is critically important too, because you can do everything in your power to conduct a security assessment and to implement a written cybersecurity plan with all those safeguards on the last PowerPoint page. But if you don't test your vulnerabilities, your annual vulnerability scans, annual pen testing, and if you don't train your employees on good cyber hygiene, all of those protocols that you have in place at the top, they're not going to filter down to the people that handle your confidential data on a daily basis. And that creates an issue as well. You know, there was a survey a few years back where some cybersecurity data gatherers surveyed those in the C-suite of an organization and asked them, how many of you have written cybersecurity safeguards in place for your organization? And something like 2/3 of the CEOs responded, yes, we do. Leaving aside that there's 1/3 that didn't. There were 2/3 that did. Then as part of this survey, the data gatherers went and surveyed the employees and asked the employees if they were familiar with those cybersecurity safeguards that those in the C-suite said they had implemented. And 2/3 of the employees said, no, they weren't familiar with them. So clearly, it's critically important to test and train your lawyers, paralegals, your legal assistants, those in your organization who are on the front lines in using and protecting that technology on a daily basis. And you want to have, finally, an incident response plan. You want to know today what you're going to do if you get up in the morning and you try to log onto your computer and you see that screen that tells you you've been the victim of a ransomware attack. Or you want to know what to do when an associate comes to you and says, you know, I was working really late. I left my laptop at the airport. I don't think I shut it down. I don't think I closed out of it. And some of the client data that I had and was working on might have been exposed. You want to have a team in place of lawyers, forensic experts, and cyber insurance coverage to make sure that you have a step-by-step protocol that tells you what you're going to do in the event of an alleged breach. We're not going to spend too much time on that here, but suffice to say that if anything ever goes wrong and data has been compromised and either a regulator or a grievance committee comes to you and asks you, all right, talk to us about what security protocols you had in place. If they ask you if you did an assessment and you say no, They ask you whether you had a written cybersecurity plan and you say no. And if they ask you if you had a written incident response plan and you can't say yes to that, that creates potential issues and potential exposure for you, not only legally to those whose data has been exposed, but perhaps ethically as well. I will tell you before we move on to virtual ADR, I have not been able to find too many ethical investigations of lawyers as a result of alleged cybersecurity incidents, but there are some. And I think that they're going to become more prevalent as more industries, including the legal industry, develops a facility with cybersecurity safeguards. Regulatory bodies, grievance committees are going to get more interested in what lawyers are doing and not doing. We're seeing that on the part of federal and state regulators. I think it's only a matter of time before it filters down to our industry as well. All right, so you've got good cyber hygiene. You've got the assessment, the plans in place, and now you want to sit down and make sure that when you're involved in virtual ADR, virtual court appearances, and communications, you have your best foot forward. Let's talk through now some recommendations that both the attorney grievance committees I've been able to see and most of the secondary materials out there tell us we should be mindful of. First, Elvin, this is an error. I'm sorry, it says remove the platform's terms of service and privacy policy. And it would be great if we could do that, but we can't. What we should do is review them. That's what that word should have been. Now, I can tell you, I have private conversations with my friends and colleagues in the business, and most people do not review the Zoom or Microsoft Teams or LifeShare terms of service and privacy policy. But you want to do that for two reasons. Number one, you want to make sure that you're familiar with the ways in which the platform will or will not use the data that you supply in connection with your virtual experience. Most organizations, most platforms today will commit that they do not use your data for any purpose other than to facilitate the particular communication, but that wasn't always the case. And every platform is a little bit different. So you want to review that. You also want to review the terms of service and privacy policy to identify what, if any, added security measures you can opt into. Very often they're no cost or at minimal cost, but you want to be able to say to a client, to say to a regulator, if anything goes wrong, yes, I did consider these additional security measures, and either yes, I implemented them, or no, I didn't for this reason. So it's critical to start with reviewing the platform's terms of service and privacy policy. I actually did this last week for Zoom. Yeah, there's a lot of fine print, but it's a fairly easy read. And after I read through it, I satisfied myself that there was nothing in the terms of service that I thought posed a particular risk to my client. So I could say that I did that, and I felt more comfortable that I had discharged my duty of competence under Rule 1.1. Second, before you participate in a virtual ADR or virtual session, you want to consider implementing a written confidentiality and information security agreement that lays out not only that any data exchanged will be confidential, but lays out the protocols that you will have in place to protect that confidential information. We're going to talk about some of those protocols as we look at some of the next recommendations. But I can tell you that AAA and some of the other ADR organizations are coaching their neutrals to implement these written confidentiality and information security agreements. In some cases, there is standard language that is used. In very often, the purpose of these agreements is to protect the interests of the neutral as well, so that everyone understands how the arbitrator or mediator will or will not be using that information. But it's a good opportunity to govern the parties as well. Everyone should understand what their duties are, how they're supposed to safeguard that information, and that, of course, inures to the benefit of our clients. Third, and this is very easy to do, but it is sometimes neglected. You want to, whenever possible, certainly in a virtual ADR, where you're dealing with a matter that's very sensitive, confidential, and in some cases, there may be privileged communications, particularly if you're in a side room conferring with your client. Want to make sure that you have a random or randomly selected meeting number for each session, and if possible, password protected. I will tell you that when I'll tell a bad story on myself. I'm working on a case now. One of my colleagues is actually from another firm. We're communicating all the time. And whenever we communicate, he sends me his Zoom link. And it's his room. And whenever we want to talk, I just click on the link. He knows I'm waiting in the room. He opens it up and we start talking. There's probably a better way to protect the sanctity of our attorney-client communications in that context. Zoom is very helpful. He's in New York. I'm here in Buffalo. It would be impractical for us to travel to meet each other face-to-face. We're working on a very big trial prep, but we could probably do an even better job of protecting our communications. And one of the ways we could do it is to create a meeting number for each session and password protect it. And I would strongly recommend that. Number 4, this sounds easy, but I'm sure how many of us have had this experience where you're in an ADR session or another session and somebody's there that shouldn't be there. Always happens, and you want to be very careful. I know in my world where we're dealing with insurance coverage mediation sessions, it's not always clear who's representing the underlying defendant, who is representing that defendant's insurance company, and whether the defendants that are in the room are aligned or adverse in such a way that they should be separated. So you just want to make clear to eyeball everyone who's in the meeting at the start, make sure that everyone who's there is supposed to be, no one who isn't supposed to be there is, and be sure to not only limit attendance in that way, but remove unauthorized participants. And it's very easy to do this at the outset by having that randomized link and password and making sure that the session is locked out to anyone that you haven't pre-approved to be present in the meeting. Number 5. This is a practical problem that I think we all face. I want to talk to you about it at the very end when we talk about special client considerations, but it makes me think of the story that I mentioned up front with the lawyer who doesn't know he's on camera in front of the appellate division, laughing and talking on his phone. People are walking around behind him. We're all in situations. I'm sitting at home right now. No one is in my home. But what if I were sitting at home and my children were here? What if I had a friend here? Is it okay for me to sit in this unenclosed room and have people in the background that could overhear my conversations with my client or could overhear sensitive information exchange during an arbitration or ADR session? No, it's not. So you want to make sure that you're in a secure place, certainly in your home, in your office, or other remote location. That's fine, but you want to make sure that it is not possible for your communications with the neutral, with your client, to be overheard. What are the chances that your communications are going to be overheard, that someone's going to notice that, and then take the step to raise an issue of waiver, that they're entitled to know about these communications, or if they've heard them, they can't unhear them and can use them because you didn't take sufficient steps to protect your communications in advance? I don't know. And isn't that the dangerous part, right? I can't trust my imagination to think of the ways in which a data or client communication could be compromised and create a waiver if these practical steps aren't taken. So I think just very important, very easy to ensure that our sessions are not overseen and that they are private. And the potential downside of not doing so can be highly problematic. So it's an important step. It seems obvious, but in all the literature it's mentioned, and there are potential risks if it doesn't happen. So moving on to step number 6, employ a clean screen policy. I'm not even going to demonstrate this on my laptop because I don't want to risk anyone on this call seeing something that's confidential, but you probably already do this. One of the things that I did before we started, I'm sure our participants, Liz and Bridget and Judge Martocci, Judge Nowak will do, is you want to make sure that the only thing open is either the virtual platform or the screen that you want others to see. If you have Outlook or email communications and other sensitive information that's open, if you can see it and you're sharing your screen, others can see it too. So you want to convert that clean desk policy into a clean screen policy to eliminate that risk. Next, secure your sensitive documents and even the recording sessions and transcripts. And that, I think, goes back to having an upfront confidentiality and information security agreement. You want to make sure that everyone, including the stenographer that you have with you, if it's an ADR session and it's going to be on the record, that you have an understanding and that everyone is bound in writing to ensure the confidentiality of the record, including any transcripts of the communications that go on in the session. There are some, as you know, I think we're recording this session right now, so you know that there are options to record a virtual session like the one we're having now. You want to make sure, though, that you have that conversation up front, because you may or may not want to record a sensitive ADR session. You certainly don't want to record a mediation session. For the most part, that's unnecessary. I can tell you, there may be others that have had a different experience. I have never needed to record either the main mediation session where the advocates are making their arguments, and I certainly would never record the private sessions in the breakout rooms with my client or my client's insurance company. So you want to make sure that you know whether something's being recorded, you decide on whether you want that to happen, and that you place protocols and restrictions in place to protect the confidentiality of those recordings, particularly if it's an ADR session dealing with trade secrets or other sensitive information that you don't want to get out. Just a couple more steps. And this is a really important one. You want to make sure that whatever vendors are involved in your relationship agree to comply with the safeguards you yourself are complying with. And the vendors could be varied, right? It could be the stenographer that's transcribing a session, if that needs to happen. It could be an information security firm that you've employed to help you with protections. It could be a trial consultant that is helping you prepare. You want to make sure that you lay out with whatever vendors you have in writing the protocols that will be in place and the protections that you will have with those vendors. I call it the 3 C's of cybersecurity for vendor relationships. And actually, on our CyberSip podcast, which we just launched in December, it's on the Barclay Damon Live website. The very first episode that I did was called the 3 C's of cybersecurity for vendors. And they are confer, contract, and comply. You want to make sure first that you have a conversation up front with whatever vendors you're using. They understand what data they are going to have access to in the course of their performance of services. And you want to have a discussion about how they're going to protect it, including whatever cybersecurity safeguards they have in place. Why do you want to do this? Well, can you imagine if something goes wrong? Very often, think of the Target data breach as one of the first data breaches we all became aware of many years ago. The bad actors did not get into Target's system. They got into the system of one of Target's HVAC vendors, a vendor responsible for heating, ventilation, and air conditioning. That's how they were able to get into Target's network, and that's how they were able to create hundreds of millions of dollars in problems for Target. So you're only as strong as your weakest link. And your vendors are your weakest link, not because they themselves are not secure, but because many of us often don't think about having a conversation with our vendors to make sure that their safeguards are equivalent to ours. So you want to confer with them. You want to, second C, contract with them. You want to build cybersecurity safeguards into your vendor agreement. And if possible, and it's increasingly possible, You want to build in indemnification and insurance procurement provisions into your agreement with your vendors. I can tell you that 2 years ago, that was not possible. I remember my first vendor negotiation for a client with a big payroll services company. And I had recommended all of these changes. I wanted cybersecurity safeguards. I wanted them to indemnify us if anything went wrong. I wanted them to have insurance to cover their indemnity obligation. And we got on the phone with their general counsel and they said, Kevin, these are great ideas. We understand completely why you're doing it. We absolutely refuse to adopt any of these provisions. And if you want to work with us, you're just going to sign our form. And we did. We signed the form because we had no choice. We did the best we could. Flash forward 2 years later, negotiating vendor agreements for one of our clients over the last month or so, we built in those same safeguards that another organization had refused 2 years back, and the vendor agreed. Why did they agree? Not because I became a better negotiator. I can assure you of that. 2 years is a long time. And what's happened in that 2-year period is that vendors realized that to compete for your client's business, they need to promise more than they did 2 years ago or even a year ago. And so you want to make sure that you have these conversations and you try to build these safeguards into your agreements with your vendors so that if anything goes wrong, your vendors will be able to answer to you if they caused the problem. And if they don't, you can turn to your client or whoever's interested and say, yes, we did everything we reasonably could to correct the data. The third C of cybersecurity for vendors is comply. You want to audit to make sure that your vendors are complying, and we can talk about that later if there's time. All right, so those are the top considerations for cybersecurity in the ADR realm. I want to conclude by talking about some particular considerations for clients, because this is where, in my research and preparation for this session today, I've seen more of the attention on the part of grievance committees and ethics organizations. So you have a client, and I will tell you, and Zoom became so popular so fast, how many of us actually sat down and thought about what should we be saying to our clients? What benefits and risks of the technology we are about to use should we talk about before we ever use it? I'm sure many of us did. I can tell you that many of us didn't. And it's critically important to do that because sometimes clients can be a weak link, not because they're not competent, but because they're busy working and dealing in their daily lives. We're sitting in our offices. They may be sitting at the office. They may be sitting at home taking care of family, and they're not as focused on these issues as we are. So they look to us. And here are some of the things that we need to do. First, you want to make sure, as we said earlier, that you have a discussion with your client about the safeguards that the client has in place. Let's use an ADR as an example. I have had situations where the client is logging into an ADR session. Maybe everyone else could make this particular date for arbitration or mediation. The client couldn't. They say, I'll be driving in my car or I'll be on the train, but I'll call in. And invariably, the client's there. You can see that they're sitting on a train, the LIR, and they're not in a secure place. You want to make sure you have that conversation up front, because technically, if anything sensitive is said to the client in that public place, it's potentially, you're in a potential waiver situation, and you want to be careful about that. You want to make sure that the client has secure Wi-Fi too. So if your client's sitting on a train and there are others around, not only is the client not in a secure location, but very likely your client is not operating on a secure Wi-Fi connection. And it's doubtful, possible, but doubtful that your client has logged in using a secure VPN connection. You want to have that conversation in advance with your client to minimize the risk that any sensitive information could be accessed or misused. And we talked about private location and using password protected links, critically important in these client communications as well. One of the things that the literature talks about as well is just the threshold question, the null hypothesis. Using technology to communicate is appropriate. In some cases, it might not be. If you are in a situation where you just know your client is not going to be in a secure location, the client doesn't have a secure Wi-Fi connection, isn't using VPN. There are fellow employees or strangers in the background, or suppose you're dealing with a client who's just not as tech savvy, not as comfortable using technology as you might be or your colleagues might be. That's a really critical point of decision for you. And you may want to say at this point, you know what, we're not going to be able to communicate via Zoom. We're going to have to do it in person, or, you know, we're not going to be able to take our client's testimony via platform, Zoom or Teams, because we just don't think it's secure. You want to be at that point where you can make an appropriate decision with your client, for your client. And if the challenges are too great, it may well militate against using technology. I've seen that a couple of points in the literature. These days, clients are increasingly facile. It's rare to find someone who's uncomfortable with the technology. Certainly in the last 2 years, we've all become very comfortable, but there is a risk if your client is not comfortable. And I've had situations where it wasn't a client, but it was an expert who said to me, you know, Kevin, I'm not familiar enough with this particular platform, and I'd really feel more comfortable if we used a different one. And we were fortunately able to do that fairly easily. And we switched platforms because we knew that there was a risk associated with using one that the expert was uncomfortable using. So that's an important consideration as well. Let's just sum up with the high points. We've talked about the rules in play and the key takeaways. And let's just sum them up here. Virtual ADR, like any other communication with a client or with an adversary today, requires a strong commitment to cyber hygiene. You want to do that risk assessment, and you want to do it at least annually. Many cyber experts are recommending, and I would recommend, that the risk assessment take place at least twice a year, and many organizations are doing it quarterly. Obviously, we're not all in the same boat when it comes to the ability to do that. A solo practitioner or a small firm is going to be in a much different situation than a large publicly traded company. But the key takeaway is you want to make sure that you do it at least annually, you do it on a regular basis, and that you make changes that are required to fix whatever flaws or glitches that you discover. You want to implement a written cybersecurity policy and an incident response plan so that you know what you're going to do and who you're going to call when there is an inevitable breach. We handle many of these. I think we're up to 45 in the last 2.5 years. And I can tell you that the process, of course, a client will call and they're set, their computer's been frozen, they can't do any work. Clients are calling, wondering what's going on. Process is so much easier if the client knows which lawyer they're going to call. If we are then able to quickly retain a forensic consultant, if we have cyber liability insurance and we immediately contact the broker or the adjuster to begin that 3-part relationship with the client of legal expertise, forensic expertise, and insurance expertise to begin working the problem. Believe me, if you have that in place, your client and you will be in a much stronger position. And lastly, as we said earlier, you definitely want to understand and communicate with your client about the benefits and risks associated with virtual technology in the ADR realm or just in the client communication realm. It's not a long conversation. It's not a technical conversation. And in most cases, a client will say, yes, I understand, and I do want to go forward. And if you can, you want to document that in writing. The trend is in that direction. I don't think every lawyer is doing that. I'm not sure. I'm certainly not prepared to say that it's ethically required to document your cybersecurity conversation with your client in writing. But as our loss prevention partner always tells us, if it's not in writing, it didn't happen. So it's always a good idea to keep that in mind. And finally, you want to meet and confer and agree with your client, with your adversary, and with your neutral to talk about what safeguards that you want and will have in place and who's going to put them in place before you have that ADR experience. So that's all I have for you this morning. I'm happy to answer any questions. And if anyone has any questions or wants to talk about something after the presentation, I think you have my contact information. And I just want to close by just thanking you for correctly pronouncing my name at the start of this presentation. That was the best pronunciation of my name I've ever heard. Is better than how I pronounce my name. So that was super cool. I really appreciate that. And it's great to be here to talk with all of you this morning, and especially honored to be here with my colleagues.
I conferred with the linguists, so.
Thank you, Kevin, for that very informative presentation. I think we all learned a lot. Does anyone have any questions? If so, can you post them in the chat and I will pose those questions to Kevin? Okay, well, I don't see any questions posted in the chat. So thank you so much, Kevin. Again, we appreciate it. Carisha?
Thank you. So we will announce our first.
Sorry, Carisha, to cut you off. Someone just posted. Kevin, what are your feelings about having someone who's an expert in technology helping a client?
Well, I think that's depending on the circumstances, I think that's helpful. I think in some cases with an individual client, it might be impractical or unnecessary. But I have client relationships, and in the cybersecurity field, we've had situations where issues come up with respect to technology and information security, and we recommend to the client, hey, here are a couple of names of forensic consultants that we use. Would you be interested in setting up a call with the consultant so we can talk through and troubleshoot the issue? Or if the client is more broadly interested in conducting a more formal cybersecurity assessment, we do that as well. I think that's a great idea and is very often appropriate and feasible. The only other thing I would mention from an ethical standpoint is that we all be mindful of the ethical guidelines that govern attorney-client communications when those communications also embrace an outside expert. Generally speaking, those communications will be protected, but what we're always careful about, because you're going to have a situation where the client's going to say, well, and we actually had this situation with one of our ransomware events. We said to the client, make sure that whatever communications you have, you copy us on them, or if we're going to do a call, make sure we're involved. And the client, not surprisingly, for the most part complied, but we found out later, the client was calling the forensic consultant without us and having communications about problems and the potential disclosure obligations the client was going to have. And while I think there's a very strong argument that those communications were done at our direction, and so they were still protected, even though we weren't present, you ideally want to avoid that situation. So it's a great question. Hopefully this answer isn't too long, but I think number one, it's a great idea when it's feasible. And second, you want to be careful to protect the privileged nature of the communications when you do have someone technically outside the relationship involved in the discussion.
Thank you, Kevin.
Thank you. So I'm going to announce our first CLE code, which is technology. The first CLE code is technology. It will also be posted in the chat. Again, the first CLE code is technology. Okay, so it is my pleasure to introduce our next speaker, Ms. Bridget O'Connell. Ms. O'Connell works as a court attorney referee and alternative dispute resolution coordinator for the New York State's Court's 5th, 6th, 7th, and 8th judicial districts, and the Court of Claims through the Office of the Deputy Chief Administrative Judge of Courts outside New York City. Bridget graduated from John Carroll University and attended State University at Buffalo Schools of Law and Social Work, where she acquired a Juris Doctor and a master degree in social work. Her path has included private practice, work with the local community dispute resolution center, teaching at the University at Buffalo, and serving as principal law clerk to Honorable John F. O'Donnell. Bridget currently sits on the New York State Bar Association House of Delegates. She has been recognized for her work with the Lamplighter Award for the 8th Judicial District's Committee on Gender and Racial Fairness, the Woman Lawyer of the Year Award from the Women Lawyers of Western New York, and the Volunteer Lawyers Project VIP Award for her work on the Pro Se Civil Litigation Practicum at UB Law. Ms. O'Connell, the floor is yours.
Thank you very much. But for Kevin's very calm voice, I think I would be in a full panic right now about my cybersecurity. Thanks so much. I'm going to talk a little bit about some of the additional ethical considerations around virtual ADR. And I think that this is probably going to highlight my social work degree a little bit more than my law degree, which is fine, both from UB, go Bulls. So I wanted to just take a quick minute first to just do a grounding exercise. And this one's called Crazy 8s, and you can do any grounding exercise you want. But this one is just the idea of sort of taking a minute to breathe and, I'm sorry, Lazy 8s it's called. So, and just sort of tracing an infinity symbol with your finger back and forth. Keep your head still and follow your finger with your eyes. And then switch hands. Just kind of follow slowly, watching with your eyes. This helps to harmonize the two sides of your brain. And although you don't necessarily want to do this at the beginning of a session virtually, because you'll get a reputation, not a bad one, just a reputation, it is really helpful, I think, to have an opportunity to sort of take a minute when you're heading into a virtual space, especially when you are advocating for a client in that virtual space, to really just kind of center yourself and make sure that you know what you're heading into. We heard Kevin talk a little bit about the importance of, knowing who's in the space and who's allied and who's representing who. And so this can be done, this kind of breaking from one activity to the next, just by having people introduce themselves, taking a minute to just kind of make sure we all know where we are. I think we've all had the experience over the last couple of years of kind of running from one Zoom meeting to another Zoom meeting to another Zoom meeting, and you get to the end of the day and you're like, what happened? Because nothing's differentiated, right? You're not in a different office, you're not at a different courthouse, you're just in your chair looking at this screen, and every activity that you do is just you in this chair looking at this screen. And it can be very challenging to really understand that you're moving from space to space and doing that. And so when we talk about ethical obligations, we're talking not just about the ethical obligations that we have very specifically to make sure we write things down and such, although those are all very important. We also have an ethical obligation to be competent in our practice, and competence means showing up and being really present with our clients. So I think it's really important to just take a minute to kind of get yourself into that space, and whether it's a grounding exercise or something that is more formalistic, like having people introduce themselves or just washing your hands between activities, it's really important to just kind of space things out for yourself and have those breaks. So today I'm just going to talk a little bit about the basics of the presumptive ADR initiative here in the New York State courts. I think it's a good time to kind of give a quick review on that to all of our friends who've shown up today. Talk a little bit about some of the ethical issues in ADR, especially ADR that's done in a virtual space, and consider some strategies to work in that virtual space while doing ADR. The presumptive ADR initiative and the ethical issues also impact sort of how we act as advocates. And so I wanted to talk a little bit about that as well. What is presumptive ADR? Presumptive ADR is an initiative that was announced by Chief Judge DiFiore in the New York State courts back in 2019. And the idea was to give parties options on how to resolve their disputes, more options, a more robust menu of options. So that includes things like arbitration and mediation, neutral evaluation, some of the things that you heard Kevin talk about a little bit earlier. And what do we know about this? Well, we know a lot, because I see we have some of our friends here from the Western District, and here in the 8th Judicial District, which is the 8 counties on the left-hand side of the state, we know that ADR is really practical and functional because we've seen it working in our federal courts for many, many years in a model that is, truly presumptive. It's presumed that you will go to ADR. In fact, it's automatic in many civil cases in the federal courts. And so we know that ADR offers opportunities for early resolution before positions harden, before costs rise. And that's exactly what we're looking to do in the state courts, is really give an opportunity to give parties a broader menu of options about how they resolve the disputes that are in their lives. As I said, this started back in 2019, and we've seen development of plans locally. We have, ADR seen as part of a solution to the court's backlogs that exist in some spaces. And we're seeing that, we're expanding the idea of having sort of consistent rules and guiding principles. In fact, there's a rule out for public comment now that would be a statewide authorizing rule with regard to presumptive ADR. So if you're interested in commenting on that or speak as an organization or as an individual, you can look that up on the court's website or contact me, and I'm happy to share that with you. Comments are due, I believe, April 4th. So one of the things that we find when we talk about presumptive ADR is that the way it's rolled out because of the pandemic and the way things were functioning in the courts is that it's kind of rolled out in 3 phases at this point. The first phase was the utilization of court staff and dedicated ADR parts. Things like the Marty Violante program that we have here in the 8th Judicial District is a good example. Our friends in the 7th District also have dedicated court attorneys who do solely mediation on matters that have come before the court. We also find that we have our community dispute resolution centers available to us. Those are public-private partnerships that function in each community. Every county in New York State has a community dispute resolution center available to them, and they provide low or no cost mediation and other dispute resolution models through their work. And we find them very, very active in places like small claims court and family court. So here in the 8th Judicial District in small claims court, we actually have a truly presumptive model that was started with our local CDRC, the Center for Resolution and Justice, it's called, through Child and Family Services. Our CDRC actually provides presumptive mediation in small claims matters in all of the courts that are outside of Buffalo City Court. So if you file a small claims action, you get a notice to go to mediation and a court date in the same court notice, and you're presumed to be going to mediation. We found that that's very successful. Oftentimes, those are cases that are well suited to mediation and early mediation. These are situations where parties want to be heard, they want something to happen immediately, and the mediation protocol that's been put in place there allows us to do both of those things. The third phase, and this is something that we've had around in the 8th Judicial District for a while, but is starting to develop in other spaces, is rosters and panels of neutrals. So much like the federal court has a panel of neutrals, we have a roster in New York State, in each county, in each district, that is full of neutrals who qualify under Part 146, which requires specific training and experience. So it's important to sort of understand if you're working with an ADR provider, or what we usually call a neutral, just exactly which of these groups they fall into and what their actual role is, and what you can expect from them differs depending on who they are. So the panel mediators are people that are working generally with their own technology. They're generally working in their own space. They may be inviting you to their office, or they may be offering a virtual option, or they may be offering some sort of hybrid option. But as we heard Kevin talk about earlier, it's really important to have a conversation with those providers up front to understand what technology they plan to use and what kind of protections exist. And if it's a platform you haven't used before or you're not comfortable with, talk to the mediator about what exactly they've put into place to make sure that this is a secure space where confidential matters can be discussed, because mediation is, as we know, confidential. In the 8th Judicial District, we have presumptive models, like I talked about before, the idea that civil cases are presumed eligible for ADR of some sort and will get some sort of ADR treatment as early in the case as practicable. You can also volunteer to go to ADR. You can say, you know what, Judge, we'd really like to have an opportunity to sit down with a neutral evaluator, or I think this case could benefit from mediation, or I think that this case could benefit from seeing an arbitrator, or I think that this case could, would be as well suited to a summary jury trial. All of those paths off of the regular litigation path are actually forms of alternative dispute resolution. And we want to think broadly about the menu of things that are available when we're advising clients about what might be workable for them. You also can have court referral. So the idea that a court can refer automatically, or because your case has some certain characteristic that they feel would be appropriate for mediation or some other form of alternative dispute resolution, they can actually refer to a neutral evaluator, or they can refer to a mediator. And as the mediators on the panels give a period of time uncompensated, and so the courts can certainly refer to the mediator for that uncompensated period of time. It's important to discuss with your clients under the rules that deal with communication how this might come up in your case. And as we see the New York courts moving further and further towards truly presumptive models of ADR in various ways, we want to make sure that we're really considering that obligation to communicate with our clients, and that we have facility with those options ourselves and with each process and what it means and what are the benefits and the challenges of each process and how that might impact our client and their case and their objectives. So we saw in the last couple of years how this world we live in pivoted to online work, and certainly the ADR world was no exception to that. We saw that our CDRCs were one of our first groups to pivot to online work, and so they were able to continue to help with family matters and small claims matters, which, though they are not often the most complex cases in the courts, they are often extremely important and allow families to and children to continue relationships with parents and other things that we would see as extremely important. So we want to thank them for their hard work over the last couple of years in being some of the first folks to pivot to an online space where they could continue to do their work. We expect that there's going to be some continuation of online work as we move forward. It makes sense that there are ways to work in these virtual spaces that are very helpful to parties, that allow parties to appear from far away, as we talked about a little bit earlier, that allow parties to appear and not have the cost of parking or the distance to drive or the time off of work, more than it just takes to actually have that appearance or have that mediation session happen. All of those things are really important to consider. And so one of the things that we want to talk about when we talk about ADR with clients and talk about how it might suit their case, how it might work within their case, or how they might be required to go because of a presumption. We want to think about whether or not that ADR, if possible, should be in the virtual space, or if it's something that would benefit from being in person when we're in a situation where that's going to be able to happen more conveniently and consistently. Coming up with a plan about how you're going to discuss technology with your clients is a really important part of your work as an attorney. And in fact, many of our ethical rules are implicated when we talk about ADR and ADR in the virtual space. Those can include competence, communication, confidentiality, my favorite rule, advisor 2.1, everyone should pick a favorite, judges as neutrals, which we find under 1.12, and lawyers as third-party neutrals. So we want to sort of take a brief look at all of those. The actual text of those is at the end of the PowerPoint that was sent in as my materials. I'm not going to go through line by line. Simon's, job is already taken. So I do want to just give you a heads up that those actual rules are available to you as part of the PowerPoint. You can review them in detail yourself. But one of the things that's most important about advocacy in ADR, especially as we look at ADR in the virtual space, is to know the process, prepare your client, and prepare your case. What does it mean to know the process? Well, knowing the process really means that you have to have familiarity with each type of alternative dispute resolution and what that actually looks like and what it means and what it would mean for your client. So one of the things you want to think about is, how do I have facility enough with these processes in order to explain it to my client, what they can expect? How do I come to understand what they can expect from the process in person, the process in a virtual space? How do I make sure that I talk to my client about important things that might go on depending on whether or not we're in person or in a virtual space? For instance, when we talk about family mediations amongst families, whether that's in a surrogate situation, whether it's in a family court situation or a matrimonial, one of the things we want to think about with our clients is safety. So there are obviously screenings that happen to assure that there's not immediate safety to anyone, but also there's emotional safety for people. We want to consider whether or not they're capable of appearing from their home. We talked earlier with Kevin about confidentiality and making sure there's not a lot of other people around. We certainly want to make sure that's true and that we have those, or that if there are people around, it's disclosed and we understand and discuss how waiver might occur in those situations. However, we also want to make sure that a client going through a uniquely emotional experience, whether it's a family matter or some of the CVA cases that we're seeing come in, also has the support that when they turn off that camera and they're no longer there, they have someone available to them to work with them and to be just present for them and witness for them in order to help them process whatever just happened. So those are important things to consider. We don't want a client, normally you would be with them, you would walk them to the car, you would have a conversation, you would make sure they were okay to drive. If you're not in a situation together, you want to make sure that you still have, a contact plan. I'm going to call you right after we finish and we're going to talk this through, or we're going to debrief, or it's my understanding, you're going to call your sister and she's going to come over and sit with you for a little while after you finish talking or giving your testimony in this arbitration or whatever it might be. That's a really important part of recognizing how the process in a virtual space can be really different, and some of the supports that exist in the virtual space can be really different than they are in a personal space when we're all together. It might even call for the client to come to your office, even if you're appearing virtually, so that the two of you are in the same space. It's always important to make sure that you know your technology well, but also that you have backups for your technology. If we can't reach you or you can't sign in, do I have this client's cell phone number? Do I have the phone number of where they'll be? If they're in a hotel room somewhere, trying to appear that way. So it's really important to make sure that those kind of things, those details are handled. And that's the kind of thing that really can change our intake procedures. Thinking about making sure that in our intake procedures, we, have email addresses and cell phone numbers, which we've had for a long time, but often, those aren't things that we make available to the courts. Are there things we want to make available to the courts to make sure that they can also get a hold of our clients, for emailing out notices and those kind of things. One of the things that is really important is to, in your intake, talk about what kind of technology might be used. And as we talked about earlier, maybe get some consent to the use of different types of technology, but also understand ways that you can work with your client in person, even if you're appearing virtually. So knowing the process and being familiar with the different ADR processes is really important. You also want to plan not just with your client, but with the neutral. Mediators are not judges. You can talk to them independently. In fact, it happens quite often. I would suggest that you not do that without letting your opponent or the other party know that you are planning to do that. Sometimes the mediator will set up a joint conference themselves just to talk about issues like technology and planning, agendas, those kind of things, the length of time they want to schedule for, whether or not there's going to be pre-mediation submissions. All of those kind of things are important. And that goes to issues like advising clients and also communication. So planning with the neutral is a part of this. It's a little different than what you might see when you're in a court setting, because planning with the neutral is an important part of making the mediation a success. You also want to talk with the neutral about whether or not this process is confidential. Obviously, Rule 1.6 implicates confidentiality, and we have confidentiality vis-a-vis our clients, but we want to make sure that we understand what process we're walking into if it's an ADR process that we're being referred to. So if we're going to a settlement conference with the judge's law clerk, is that confidential? Are we going to a court attorney referee for a settlement conference, which is maybe not confidential, or are we going for mediation, which is confidential? And how are we confirming the differences in those processes? It's really important that it be made clear to you by the neutral, so that you can make it clear to your client what process this actually is and what is expected to happen, and whether or not this process is going to be a confidential process. The closer one is to a decision maker, the less likely that process is to be totally confidential. And so you want to make sure that you're clear with your clients about what actually is going to happen. We also want to make sure that we're preparing our clients. Like I said, you want to make sure that they're safe emotionally and physically. You want to make sure that they understand what the role is of you as the attorney in the process. So the way we act in a litigated matter is very different than the way we act as attorneys in a mediation session, almost always. So you want to make sure that your client's prepared for that. Gosh, Bob, just so you know, You've already seen me in court as we argued about that discovery motion, but now we're going to mediation. And I just want to prepare you for that and tell you a little bit about how that's going to look and how I see my role in mediation, so we can make sure that you're comfortable with my plan and how I'm going to approach this. That's a really important thing, because we don't want clients to not have expectations met. And we want to make sure that we're managing those expectations so that it's clear what they can expect from us, what that's going to look like, how it might be different than a courtroom when they're not disappointed or frustrated or complaining to the grievance committee. We also want to make sure that we exercise our role as advisor. The reason that advisor is my favorite role is that it talks about giving advice, not just on the law. We are, in fact, obviously there as, if we're representing clients, we're there to give advice. We're there to make a recommendation. We're there to talk them through pros, cons, what ifs, all of those things that is part of our role. But a lot of times, we tend to shy away from the opportunity to consider with a client more holistically what their approach or what their future might look like. And there are often considerations. The timing of being reunited with your money is sometimes important. Having the RAM freed up in your head because a court case is closed. Imagining your life without having this court matter hanging over your head. Those are all considerations that aren't necessarily legal considerations. And so it's really important that we think with our clients about all of the things that go on. And when we look at 2.1, it actually talks about the fact that in representing a client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering advice, a lawyer may refer not only to law, but to other considerations such as moral, economic, social, psychological, and political factors that may be relevant to the client's situation. And I think that's so important to really think about this client as a person in the world and what exactly is going on for them. It helps us to think about what kind of process would suit them. So when we're talking about alternatives to litigation, we need to think about, how will this client hold up? Much like we think about how would this client hold up on the stand, we also want to think about how is this client going to hold up in mediation? What is their style of conflict engagement? How are they going to manage this? Am I prepared as an attorney to work with this client in that setting? Giving that kind of information to a client about, I know it's important to you to be a good parent, or I know it's really important to you to continue this business with Bob. You've been partners for a really long time. This seems like a glitch in your relationship. How can we think about creative ways to resolve this short of litigation? Because I know you can't pay the buyout number that's in your agreement, or whatever that conversation might look like. It's important to sort of be comfortable having those conversations that are beyond just the scope of what the law would dictate and take a more holistic view. So that's an important part of preparing your client. It's also important to prepare your client for the role of the neutral. So have them understand what the neutral's job is. They're there to facilitate a conversation. If they're a mediator, they're there to help organize a problem. They're there to help us think about possible solutions. They're not there to decide the case. Having a conversation about managing the sense that people may have that the mediator has a great deal of authority when really they don't is an important part of teaching clients to sort of balance what they're looking at. It's really important to think also about having them understand the confidentiality and what the actual neutral's job is. It's the job of the neutral under 2.4 to explain what their role is and how it differs from an attorney representing a party. But as an attorney representing a party, you want to prepare your client to hear that conversation from the neutral and understand what it means for them individually in their role, in their case. The third thing we really want to think about is preparing your case. You obviously want to make sure there's no conflicts. You want to make sure there's no conflicts for you, and there's no conflicts with the mediator or the organization that's providing the mediator or arbitrator or anyone else. We really want to talk with clients about the realities of discovery, and that goes to the timing of ADR. Look, you know what? We could do 5 depositions, but why don't we do 1 deposition and then kind of see where we are and whether we're ready to have a conversation? Or why don't we do no depositions and see where we are and whether or not we have, some general understanding in common about how we might resolve this matter. Those kind of things are important to talk about with clients, including the cost of discovery. And obviously, we're not saying we don't do discovery, and we're not saying we give short shrift to things, but sometimes if there were 4 people standing on a corner and the sense is that they're all going to give the same story, we don't want to depose all 4 people and go through the cost of that if maybe one story is going to get us some sense of what witnesses are going to be saying. So we also want to talk about language. And, if we were to settle this arrangement with your partner and you're to reform your partnership agreement, what kind of language would we want in there? Because this problem came up because of A, B, and C. We want to make sure that we're putting some language in that's going to prevent that happening down the road. What kind of things do you want to see in there? And so it's really important to think about what kind of language you want in any agreement that comes out of an ADR process, and think about bringing that with you so that you actually are prepared to help craft the final agreement and make sure that you're not just agreeing in concept, but that you're agreeing into the specifics, and we're not getting excited about the concept of resolving matters without really resolving them. So it's really important to talk through with your client, what exactly is it that you want to agree on. And it's especially important when we talk about doing this work in a virtual space that we think about how we're going to share information with the mediator or the other party that might come up. We don't have the option to sort of lay the papers on the table. We don't have the option to kind of whip something out of our briefcase to save the day with perfect language at the last minute. So we really want to think about how we would share that information, what kind of things we want to maybe exchange in advance, how we're going to handle signing the agreement to mediate, how we're going to handle signing any memorandum of understanding or other document that memorializes the outcome of the session. So those kind of things are unique to our new world. And so we want to be sort of thoughtful about how exactly we would go about that. And that sort of goes to the logistics of the ADR session. How exactly are we going to be working? Are we going to have opening statements? What are we preparing for? And the other thing I would say is a level of competency that attorneys should be thinking about is sort of understanding how you function in that space. There's a lot of fun little quizzes, and I'll pass one on to Carisha and Sarah later on to send out to folks who attended about sort of understanding your response to conflict and your conflict style. And so understanding how you function in a space where you're there to support a client in trying to resolve a matter without litigation is important, because we often revert to what's comfortable. And for those of us who have been litigators for a really long time, we revert to being a litigator. And the tone and the process and the way of asking questions and the eye rolling and some of the stuff that sometimes goes along with that can very easily come back to us if we aren't working to suppress it and function as a different type of advocate in a different type of space. And so we really want to think about how we function in that space and make sure that we are comfortable with some of the things that come up, because mediation is not just about the legal issues at play. It often can broaden the issues in order to resolve the problem. We talk about more than what might be in the complaint because we want to resolve the matter. And that's not true of every situation or every case, but it's often true that mediation allows for a larger conversation to resolve the issues, sometimes more comprehensively, sometimes for a longer period of time, sometimes to avoid recidivism and returning to court. So there are lots of reasons for it. It can be very beneficial. It can allow us to think about creative solutions. It can allow us to think about sustainable solutions. It can allow clients to have more confidence because they really talked things through. We find that clients are often more compliant with agreements that are reached through mediation. And they have a different level of trust in the process because they felt heard in the mediation. So those are all important things, but we just want to sort of think about, are you ready for that conversation to get bigger? Are you ready for these two sisters who are fighting about mom's house to, there might be tears, there might be frustration, there might be anger. Is that something that you try to tamp down and say this isn't the space for that, or do you own that this is the space for that, and you kind of allow your client to have those bigger emotions in that bigger space, and you think about what it means when a client's repeating themselves. It means they're not feeling heard. How do you take a beat and make sure that that person feels heard? And maybe it's not your own client, maybe it's the other party that you want to make sure they feel heard, and so you kind of reframe for them, you kind of reflect back to them what they're saying, so they know even that lawyer knows what I'm saying, and then they calm down and they have confidence in the process and they can move forward and broaden the conversation and have the discussion about resolution. So I think it's really important to sort of get comfortable with those kind of things, and if you're not, call me, we'll talk about it and how to practice. So mediation, as I said, is, and this is kind of the presumptive model, we expect that things will go to mediation unless another suitable option is available or is more suitable. But mediation is kind of the crux of the presumptive ADR initiative, the way the current proposed rule reads. Mediation is a confidential process. We already talked about confidentiality. It's important to sort of think about clarifying what this is. And when I said it's important to know what the process is, I'm offering this definition just so it's sort of clear to everyone that this is the definition we kind of go back to and think about. One of the things that I really like about the concept of mediation is that it's got a real process behind it. And I think as an attorney, being familiar with the process and how that process looks online is an important part of your representation and your meeting your ethical obligations. So this is the very general process of mediation. What I should have put in the background is just like a pool full of Jell-O, because sometimes mediation done right means mediation feeling like you're kind of trying to walk through Jell-O a little bit. And as attorneys, we often want to move things along. We often want to be more efficient. We often want to just cut to the chase. Sometimes appreciating that the process is a process for a reason, and that bits of it build on other bits and can really cause the ultimate resolution to be more fulfilling for parties, more sustainable, as I said, and to have more meaning for the parties, which can often result in their being more compliant with it, possibly finding ways to resolve future conflicts short of expensive litigation. All of those are seen as good things. And so it's really important to sort of let the mediator manage the process. They're not there to manage the outcome, but they are there to manage the process. And it's important to work with the mediator to understand what their style is and how they plan to conduct this, especially if it's going to be online. Not only the safety of what's going to happen online, but how do they plan to hold this mediation? How do they plan to work through things? How long do they think it's going to take? And being patient while the mediator sort of lets things happen. Oftentimes mediators are quiet and sit back and kind of let parties fill that silence because that gets them talking. But it's important to let that happen and not feel like you have to jump in, because the process, if your parties are there, really belongs to the parties and it's being managed by the mediator. It's also important to understand ethically that other professionals in the room have their own ethical obligations. And so familiarizing yourself with model standards of conduct for mediators, Kevin alluded to the online obligations that are being outlined by AAA and some other folks. That's important to know about and to understand. So it's just important to sort of appreciate that there are other ethical obligations going on in the room and appreciate what those are and how those might show up so that you can adequately advise your client. I said before, it's really important to be clear about roles, and this basically just reiterates that. 2.4 had been under some discussion by COSAC to get some changes to it, but that hasn't quite happened yet. Again, in consulting with clients about what process to use when that's an option, really considers both the good and the bad. So it's really important to think about, what is there to discuss here and whether or not this process mediation is suitable. Maybe this is a matter where a neutral evaluator, someone else in the room, a new voice in the room is important and something you would want to consider instead. Maybe this is something that's suitable for collaborative law, something that's wholly outside creature of contract, the court's referral process. So looking at this, I just wanted to mention the one thing about, we recognize that there are cases that even in a presumptive model are not suitable for ADR or mediation. And those include cases where there's great disparity in power between the parties, or there's power and control issues, coercive control in the past. And so there's screenings that happen in order to address those things. But it's also important to make sure that your client is able to function, even if those aren't the issues. And so understanding the limitations that some people may have, especially in a technology situation. So I'm hearing from a lot of people that actually the technology is helpful in really emotional cases. Sort of not having to be in the same space can be really helpful. Not because the person's in danger, but just because they're emotionally engaged. And so having that little remove, that little distance is important. But you also want to consider where your client's appearing from. Are they able to function? Maybe they want to be in their home in order to make this appearance. You want to make sure you have appropriate supports in place, but you also want to consider like what's in the background. How much of their life are you allowing the other people in this space to see into? And how might that impact them down the road, or when they realize, oh gosh, you saw my piano with the picture of the kids on it, like that's changing everything for me. So it's important to sort of think about, what's in the background and counsel your client about how to limit the invasion that sometimes these cameras can be. It's also important to sort of talk through the hows and wheres and why for what, wherefores, how, why, wherefore, of deciding whether or not this is a suitable case for an ADR process. So thinking about a creative solution is a great reason to go. Parties having an ongoing relationship is a great reason to go. Trying to sort of limit cost, try to get early interventions before positions harden. Those are all really good reasons to go. We do want to be really careful about cases where the problem's just unmediatable, where sunshine is important for some reason of precedent or other public concern, or there's some sort of history of abuse or a party's unable to function, even with proper supports in place. We also, want to think a little bit about how we explain all of this when we're talking to clients. And Kevin talked before about making sure that when clients are in a space that appears private, that you're still checking in with them to make sure this is a private space. We have stories from our mediators of people who were getting on planes. That didn't seem like a good place to hold a mediation. We have people in cars. We have people driving in cars, which seems like we're all going to witness an accident, and then we're all going to have a different kind of mediation where we get called in as witnesses in this accident. So that's going to be bad. But we sort of want to make sure that we actually are checking in with the client. Are you someplace that you can talk? Is this confidential? Is there anyone around? And explain to them what that means and the kind of things that could impact that confidentiality. So we talked a lot about some of the things that need to be consulted about. That includes costs, the time involved, the process. We also want to really be careful about counseling clients about how to function in the ADR session. So making sure that they understand that they should listen, that they shouldn't interrupt, and thinking about how you're going to sort of nudge a client who might not be present with you. There's no kicking under the table when you're in two different spaces on two different cameras in two different towns, or maybe two different cities or two different states. So it's really important to sort of think with a client, how am I going to sort of cue you that you need to calm down? Or is there a word that would help you remind you that you need to not interrupt? Because you don't want to impact your client relationship by shaming your own client for some behavior that they exhibit. You don't want to call them out on things, strategically maybe, but rarely. So I think it's really important to sort of think about how are you setting aside time to prepare your client, really prepare them for, like, these are the rules. Let's write them down. Let's think about this together. This is kind of how we're going to conduct ourselves. This is how we're going to move forward. I know this is really emotional. What's going to help you to stay calm? Like, what can we do to make sure that you're going to be able to have this conversation? What are we going to do if you feel like you can't carry on? Are you going to message me that you'd like to take a break? Like, what would you like to do? So, so it's really important to sort of work that through with the client, and also sort of help them imagine a future, a preferred future where this conflict is no longer a part of their lives. That can often be really engaging and a really good reason to utilize ADRs, that people have an imagined future where this conflict is just over and they can move on. This is a checklist that might be helpful as you sort of think things through with clients and think about the mediation process in this new virtual space. Including talking about benefits and drawbacks of virtual versus in-person, the cost of litigation, the costs of travel or other things that might be involved in trying to appear in person are something that, were just a known cost before, but now it's something that you might want to consider as far as an option. It's really important when you're in any ADR process, but we've sort of been focusing on mediation, to act in good faith, to be as respectful as you can be, and to be patient, because a lot of times those non-legal issues take some time to work through as we try to get to the crux of the matter that brought them into court. We want to make sure that we're attending to and giving time to those other non-legal issues that might really help support the solution that comes out of ADR. When I talked a little bit before about preparing yourself and sort of knowing your conflict style, it really is something that can be important. Understanding also that hearing about other people's trauma, whether it's a car accident, a family dispute, some sort of abuse, is over time a trauma for you. So it's really important, especially as we head into some of these CVA cases and other things that are coming up, that we're aware that repeated exposure to the trauma material of other people is in fact a trauma of its own for you. So as a professional who's witnessing that experience of others over time, that's what we have the term vicarious trauma to describe, this idea that it becomes something that can be triggering for you, and you can have all of the experiences of trauma as well. You can have intrusive thoughts, you can have flashbacks, you can have, physical reactions, you can have difficulty working with those clients, you can have results that can impact your ability to function well as an attorney, because your desire not to hear about this client's particular trauma or particular injury or particular experience in life makes you feel like, oh, I'm gonna, I'll call them back at the end of the day, and then maybe you don't call them back, and then I'll call them Friday. And you're just kind of avoiding that work or that case. And that can be, obviously, it's not right. And it's something that can impact your ability to be compliant with your ethical obligations, because you're not attending to the way that their case is impacting you. Jean Coe-Peters does a lot of research on trauma, especially in the legal field, and vicarious trauma, especially in the legal field. And she reminds us that it's actually our obligation to take care of ourselves and attend to the ways that trauma can impact us, so that we are not impacting our clients negatively by our inability to sort of manage in those spaces. And so part of being competent is to make sure that we are attending to ourselves and our own needs. And in this virtual space, that means also being aware of the way that being online all day can impact us, the way that our health is impacted by sitting all day, and making sure that you take a break and get up or take a walk around the block. It's also really important to sort of have a break, to be off a screen once in a while. And so if that means that you talk to the mediator and say, I can't push through till 9 o'clock tonight, but I can start at 7 o'clock tomorrow morning, or I can, why don't we take an hour break and everyone have actual dinner and we'll come back and continue until 9 o'clock. So those kind of things are important. And it's important to recognize that you're not being less of an advocate in not pushing through or forcing yourself to do things. You're actually being a better advocate in making sure that you're taking care of yourselves, so that you're attending to things in a way that allows you to continue and consistently be a competent advocate with something to give to your clients. And when we talk about, being responsive ourselves, we also want to make sure that we're recognizing that, we can speak together about how we want virtual spaces to look. We can think together as units, as firms, as bar associations, as alumni associations. We can collaborate to kind of make this virtual space that we're going to continue to find ourselves in more tolerable, more workable, more safe, more a space where we can be assured that we're meeting our ethical obligations. And that really requires us to work together. We can respond as organizations, we can call upon ourselves to respond, and we can work together to respond as affinity organizations that are important to us. So I think that's pretty much my time. I just wanted to say thank you. I hope I didn't dump too much information on you. I am a fast talker, so you should actually get 2 hours of CLE credit for my time, but you don't. So I just wanted to mention, ADR is very much in the mix in our state court system. It has been in the mix in our Western District for a really long time. They do an amazing job. But we're starting to see it used more and more in our state courts. And so I just wanted to say, as things are developing, please feel free to reach out. If you have questions, it's an open door policy. We're really hoping to onboard a district coordinator for ADR in the 8th Judicial District. We weren't able to do that before the pandemic. So you've had me doing half of that job and half of my other job, and that's never good. So we just want to really make sure that we're supporting that person and that we're being responsive to our constituents as we're onboarding them and connecting them with organizations like yours and with your firms and other things so that they can be really effective as they step into this role. I want to just say thanks to those I borrowed from in working on this, and thanks to you guys for having me. It was great to work with everybody and with my colleagues as well.
Thank you, Bridget. There were a few questions posted in the chat. The first, how is it determined when a matter is unmediatable? That's a hard word to say.
Unmediatable? It's not a real, it's definitely a red underlying word from
lots of syllables.
Like, yeah, that's not a real word.
And then along that topic, what if the court's requiring it? What advice do you have to litigators to handle that in that situation?
So, unmediatable can mean a lot of different things. I think what we want to be cautious of are cases where, where the crux of what's going on is just not something that there's negotiation to be had over. So the yes or no of a neglect or abuse situation is not mediatable, even though those are technically civil cases. However, the permanency plan for a child who is in a neglect or abuse case in family court is something that is mediatable, because that kind of planfulness, that kind of bringing people together, that sort of collaboration between grandparents and kinship givers and foster parents is something that we can discuss. So the kind of, the raise of the case, the actual whether or not this happened, that's the ultimate disposition in the case, that is not something that's mediatable. But what we do with a situation that has certain challenges in it and certain hopes for a child and how we build something together in that situation, that's something that's mediatable. So if a court's asking you to go to mediation and or directing you to go to mediation and you feel like this is not a mediatable case for whatever reason, it is generally those referrals are made pursuant to court order. My sense is that most judges are willing to have a conversation about whether or not the case should go if you call your opponent and ask for a conference. But there's also the opportunity to use mediation, even in a case that might not be fully mediatable, to help with the organization of the problem. So one of the things we hear consistently from the judges about cases that come back from ADR that haven't fully resolved is that those cases are ready to go. The attorneys are organized, the parties are organized, they know the issues, they've had a chance to clear out some of the noise about what might have been going on in their head, they've had a chance to sort of put some things on the table and talk them through, and they might have resolved some small issues. They might have resolved the terms of a confidentiality agreement. They might have, that's going to govern discovery. They might have worked out, a couple of issues that were in the complaint that actually they're not going to be pursuing, and they've kind of agreed that they can knock those out. So those kind of things can often be the outcome of ADR as well. So if you're being asked to go and it's something that you feel you have to follow through with, and it's not an unsafe situation, obviously, which is a different conversation, open your mind to how you might utilize that process to be a good advocate for your client and to effectively use that process to help move the case along and down the field a little bit.
Thank you for that answer, Bridget. The second question was, with virtual mediation, are there any disclosures or instructions that mediators are giving in this virtual world? And as follow-up, is there any way to prevent the recording of the mediation session?
Well, I think as Kevin had mentioned earlier, it's really important to sort of clarify at the beginning of each session what exactly is going on, that no one is recording this, that this is a confidential session, and that you're governed by the same terms that would be in your usual confidentiality agreement, which hopefully is being circulated in advance, discussed in advance, and executed in advance, and reaffirmed as parties are together on the phone or on the Teams call or whatever. I don't know, I know that mediators are covering this as part of their opening statement, as part of their agreements that are being circulated, but there is not any specific language that is being required of them right now. I think they're using their, good insight and maybe their conversation with Kevin's firm to decide how they're going to manage that and what disclosures are appropriate for them in that situation. But I think that, I would certainly agree that it's important to make sure that you are not just saying things as part of an opening statement, but that you're actually confirming them as part of an agreement to mediate, so that parties are clear on what's happening, what's confidential, what the role is, what the expectations are of them, including the expectations that you have for them around technology. And one of the things I didn't mention, but is also really important, is there's just so much work going on about, rural justice and spaces where we don't necessarily have good broadband, where we don't necessarily have the ability to access the technology. And that's a real access to justice issue. So when we look at those kind of things, when we talk with clients, that's another part of checking in with them. It's just sort of like, where can you be that you can actually commit to being on a call for 2 hours or whatever it would take. And you can consistently appear and have good quality and hear the rest of us talking and not have a problem. In many areas, they're starting to develop some like kiosks where people can go and use public Wi-Fi of some sort in order to have those experiences. But it's something to really check in with your client about, and to make sure that you're familiar with what resources might be out there for them to use. Your office is one, but where else might they go in order to have a private space where they can participate in that mediation?
Thank you, Bridget. I don't see any other questions in the chat, so I'm going to turn it back over to Carisha.
Yes, thank you, Ms. O'Connell, for that wonderful session. I am going to announce our second CLE code. Our second CLE code is mediation. Our second CLE code is mediation. This will also be put in the chat. The second CLE code is mediation. I will also turn to our next speaker, Ms. Elizabeth Midgley. Ms. Midgley is a founding partner of the firm Stillwell Midgley Visco in Buffalo, New York. She is an experienced trial attorney who focuses her practice defending matters involving medical, dental, and professional malpractice, long-term care facilities, legal professionalism and ethics, and general negligence litigation. Liz is the current chair of the Bar Association of Erie County Judiciary Committee, which publicly rates candidates running for judicial office in Western New York. Liz was appointed to the 4th Judicial Department to serve as a member of the Grievance Committee of the 8th Judicial District from 2015 to 2021. In June 2018, Liz was also appointed to a 5-year term of the Town of Orchard Park Ethics Board. Liz has been recognized by the Buffalo Business First 40 Under 40, Buffalo's Legal Elite, Super Lawyers Upstate New York Rising Stars, and Super Lawyers Upstate New York. Liz is a 2006 graduate of the University at Buffalo School of Law. She's also a 2003 graduate of SUNY Geneseo, which is my alma mater. Liz, the floor is yours.
Thank you so much, Carisha. Can you guys see my first screen, the common grievances and pitfalls? Okay, good. I wanted to make sure you weren't seeing my confidential information, because Kevin has me terrified now about anything that I'm going to share on my screen. I am honored to be presenting today. Thank you so much for asking me. Thank you to Sarah and Carisha and Michelle for putting on a great program so far. And I'm just so thrilled to be presenting with Kevin and Bridget and Judges Martocci and Nowak on such a really fun program today. You guys are not going to find me fun after the end of the common grievances portion. Nobody likes to hear this part of the presentation, but it is something that everybody really needs to be cognizant of, especially during virtual proceedings. So with that, we're going to get into the overview of some of the most important ethical obligations that we all have to be mindful of when we're working remotely. You've already heard Rule 1.1 with my two previous speakers, but we'll get into that a little bit. Diligence is something that has also been touched on a little bit, but we're going to dive into that a little bit deeper. There's also confidentiality that everybody has talked about, but I'm going to talk about it in a little bit of a different way. Supervision, rules 5.1 and 5.3. And then unauthorized practice of law, which I hope some of you guys have to worry about. And I'll tell you why I say I hope that you have to worry about that. So moving on to, and I apologize for taking a lot of sips of water. I'm just getting over COVID and it's the thirstiest experience of my life. So I'll be taking a lot of sips of water. Rule 1.1, competence. So I'm going to actually give an overview of the rule. I hope you all know what it is, but I'm going to say it anyway. A lawyer has a duty to provide competent representation to a client. And competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation of that client. And I say this because a lot of the concerns and ethics opinions that we've seen coming out in the last 2 years during really the influx of all of the virtual practice have to do with competence. Every single one of them, as you've seen from Kevin and Bridget's presentations, have mentioned competence. They both talked about 1.1. Kevin did an excellent job covering competence in technology. And I'm going to talk about two really important decisions and suspensions that have come down as a result of technology. And you saw this in Bridget's slides too, how important it is to be competent in an ADR proceeding and know what the mediator is going to require of you, what the mediator is going to require of your competent. I'll say, as Carisha said, I spent 6 years on the grievance committee, and I just came out in June from my time on the grievance committee. And it was the best and most saddest and most fulfilling time in my career so far. And I know that our principal counsel is on this CLE today, Peggy Callanan, and she's also helped me because I wanted to see what they've seen since I've had my time off. So some of the information that I'm getting here is thanks to her. So I wanted to thank you, Peggy. But from my time on the grievance committee, I can tell you so many grievances start with one little complaint in intake, and then they end up with so many other rule violations. And almost every single complaint that we would see or grievance that we would see would have some kind of Rule 1.1 competence aspect to them. Whether it was the attorney didn't know how to, didn't know their attorney trust account and they were incompetent for that reason, or they're not competent, like Kevin said, with their technology and they didn't have the proper settings. I'm a medical malpractice attorney. I represent hospitals and physicians. Can you imagine all of the confidential, protected patient information that we have in my computer system right now? So Kevin made me realize that I have to do another penetration test for my company. I think we have it scheduled, but I'm going to up it and probably do it in the next week, because there's so much information that we have as attorneys. We have so many social security numbers for people. I have social security numbers for everybody that has sued every one of my clients. So I have to know, as an attorney, I have to be competent in technology. The days of being able to say, I'm a Luddite, I don't understand technology, those are far past. Those have been passed since I was in law school, I think. And that was, I graduated 2006. That's not okay to say anymore. And if you don't understand the rules of technology, you are required to align yourself with somebody or ask somebody, hire somebody to help you out. You can't just stick your head in the sand and say, I just don't understand them. So for your own good, please understand some technology or find somebody, call somebody. I think Kevin probably is a pretty good person to call. sorry, Kevin, to help you with technology. So next rule that we're going to go over is rule 1.3, and that's diligence. Diligence is a lawyer shall act with reasonable diligence and promptness in representing a client, and a lawyer shall not neglect a legal matter entrusted to the lawyer. And Bridget brought this up. She set me up perfectly for this one. She brought up trauma during the pandemic and avoiding specific clients and not calling them back. During pre-COVID times or now, I had my assistant who would come in and say, you have to call back Dr. So-and-so, even though Dr. So-and-so, I knew he would be on the phone with me forever, and he kind of made me pull my hair out. I didn't really have that client. I'm just making this up, but, or whatever client it is, you know, that's going to talk to you for 2 hours and it's going to be about the same thing. And it's just really difficult to just feel like you're going over in circles and circles and circles, and you feel like it's kind of a waste of time. But you have that, your legal assistant before saying, you know, it's time to call them back. You got to call them back. Or you had a paralegal do it, or you had a legal assistant. Well, that wasn't happening so much during COVID. That's not happening so much during these virtual times. So there have been a lot of complaints lately to bar grievance committees, and just complaints coming in that lawyers have been neglecting client matters, that they aren't calling their clients back, that they aren't taking their phone calls. And when the courts were closed, lawyers were saying, hey, the courts are closed, we can't do anything. And there was a big backlog, and that was slowing down cases, of course, and that's acceptable. I mean, that was something we couldn't handle, but at least communicating with your client that that was what was happening, that was pretty important to be doing during that time. The world felt like it was shutting down, but your client's case was still really important to them. So even now, while things are backlogged, it's really important to still be communicating with the client. So make sure that you're not just communicating verbally. It's really important. And this is something that we would see in the grievance committee. If you can have written communications with your client, even an email popping in saying, hey, cases are still really slow right now. It's going to be some time before we can get in front of a judge, but I promise you that things are happening, things are starting to move. Have written communication, just so if they do complain that their case is taking too long and they take it to the grievance committee, you can say, no, I was checking in with them every 2 weeks, or I was checking in with them monthly, and make sure that you are, you know, especially if you feel like it's a client that might be getting a little bit frustrated with you, do it in writing too. So that's diligence and communicating with your client. Even when it feels like the rest of the world is shut down, make sure you're doing good communication with your client. Next, we have confidentiality. And I'm not going to read this rule to you. I'm pretty sure you all know confidentiality. So what I will say is the virtual practice has gotten me pretty terrified of ever being a client during this time. And Kevin kind of touched on this too, because confidentiality was never really a problem when we were in courts with closed doors. But now, as I mentioned, I deal with super sensitive HIPAA protected information. And every single day, when we are in either pretrial conferences with judges, or in depositions, or in mediations or ADRs, I see people sitting at home, and that is 100% fine. People aren't back at the office, and that's where people choose to work. But there are times that I see other people walking behind them. And there are times that, you know, I see a little kid running around, and I am really afraid, just like Kevin said, about waiver, especially if it's attorney-client privilege. And I'm really concerned about what other information is getting out there and what kind of protected information is no longer confidential, or we might be at risk of leaking out there. So I'm going to tell you a little bit about what I cover for depositions, and with when I'm first prepping people and when I'm deposing people. So when I am taking somebody's deposition, I ask them and it's virtual, I'll ask the deponent, I will say, is there anybody else in the room with you? And if they say no, I say, can anybody else hear our conversation? Because I also want them to make sure, I want to make sure that they are being completely forthright, completely open, completely honest with me, and that there's absolutely no chance that anybody's going to overhear anything too. Because, you know, typically back in the days, depositions were held in a court reporter's office or my office, and it was me, the deponent, another attorney, and the court reporter, and the door was shut. Well, I'm worried that this person might not be forthright with me if mom is sitting in the other room and she can hear everything with the door open. So if they say, no, nobody can hear anything, I'll say, well, is anybody else in the house with you? And then I'll see what they say about that. And if they say, yes, somebody else is in the house, I'll say, well, can you make sure that you're in a space where nobody can come within earshot? And I'll see what they say to that. Or if they say, nope, I'm totally home alone, I'll say, is there a chance that anybody could come home? They think I'm nuts when I'm asking all these questions, but depending on what we're asking about, it could be confidential information about business formation. It could just be any kind of protected health information if it's a physician or a doctor. And I want to make sure that everything is protected. And I will say, if anybody comes in the room or if anybody comes home, please let me know, because I want to make sure that we can speak openly and there's no confidential information that is getting out there. And that is typically something that we discuss. Then if I'm also asking a conversation, if I'm asking a plaintiff questions, because I'm a defense attorney, I'll say, have you discussed this case with anybody? And they typically say, yes, my attorney. And I'll say, well, was anybody else in the room? When is anybody else able to hear that discussion? For the same reason that Kevin brought up. I want to know if that conversation might have been waived. I want to know if there were people running around that shouldn't have been running around because it was in a virtual setting. So if so, I'm probably going to ask questions about it. Their attorney is going to object to it. I'm going to say that I'm entitled to those questions because they didn't have attorney-client privilege, because they didn't make sure that it was a protected conversation and they were the only two people in the room. So that's something that you have to be cognizant of in these virtual times. And that's why I always, and even during COVID, was still meeting typically with my clients one-on-one. We were masked, we were in conference rooms, but I was a little too worried to meet with people virtually because I don't trust the virtual proceedings 100% in some of the very, very, very confidential settings. So that's confidentiality. Next, supervision. This is about supervising other attorneys and non-lawyers. So it's something that I typically didn't really think about on a day-to-day basis, my obligations as the managing partner of my firm, or the managing partner, anybody that manages other attorneys or has a supervisory role of other attorneys or of support staff. You might not have thought about it so much day-to-day before COVID, but as soon as people were virtual and you weren't seeing people every single day, I started thinking about it a lot more. And most of the articles, the ABA decisions and the ABA opinions, and all of the opinions I've found, they talk about supervision and how important it has become during virtual times in virtual proceedings. So as the managing partner of my firm, this virtual time, especially when we were not in the office, was very stressful, because I wanted to make sure that all of the other attorneys were conforming with the ethics rules. And it's especially hard for young attorneys. We had a very young attorney working for me who all of a sudden I wasn't seeing on even a weekly basis. And I had to make sure that she was doing everything ethically. I wasn't popping in her office. I wasn't talking to her every day. We also had a brand new staff because Rule 5.1 is for attorneys. Rule 5.3 is for non-lawyers, and it's supervising non-lawyers. We had a brand new staff member who had worked with us for 3 days before we had to shut our office down. So I didn't know her. I didn't know her abilities. I didn't know if she was going to be putting my signature on things that she shouldn't be putting my signature on. So we have to make sure that no ethical problems arise and that no ethical rules are violated when we're supervisors or managers. So how to do that? I recommend, and a lot of the articles and the opinions out there recommend you check in often. You're asking other people in the firm, how's so-and-so doing? How does she see? How do her abilities seem? Have you seen anything? Is she talking to you? Is she asking a lot of questions? Are they good questions? I was checking all of their work very diligently. Everything that went out the door, I was making sure that it seemed 100% appropriate for a period of time. I was setting up meetings. I asked for weekly meetings with the associates to go over anything. And if they said we didn't have anything to go over on cases, we were still having the meetings regardless. And I was having meetings with the staff members too, to make sure that they didn't have any questions and that everything was okay. I was asking, what they had gone over during the week, what was going on with other attorneys' work, to make sure that things were balanced. I was also finding articles about virtual workplace and how to work in a virtual workplace and best reminders and ethical reminders, and sending them to the firm as a whole, not just to the attorneys. I'd send it to everybody. And I sent them typically on Friday, and I'd send them with other fun things so that it would get them to read the whole article and also have some ethics reminders in there too. I'm going to tell you a story about some staff gone bad that is from somebody that I know that came to me to ask for some advice, and I asked in turn other people for advice, but it's another person who was managing her own firm, and she was doing the same thing that I was doing during the virtual time. Their firm was doing 1 week in, 1 week out, and kind of splitting between two teams. And she had noticed that somebody had filed something on one of her cases and the document wasn't correct. It was an incorrect form submitted, but it looked like she had signed it or she had notarized it. So she was very confused about why she notarized this form when it was the wrong form to use. So she looked into it, and it wasn't even a day that she'd been in the office either, with the date of her notarization. So she called the assistant that had been in the office that day, and she said, I'm really confused about what happened and how I notarized this document on this day. And the assistant broke down and said, we had to file something that day, and I thought this was the right document, and there weren't any other attorneys here. So I took your notary stamp out of your drawer and I notarized the document and I filed it. So immediately she said, well, the attorney terminated her. She said, you're not allowed to do that, of course. I'm sorry, you're terminated. And this is the reason. And she put a note to the file. Then she called her HR, outside HR, and said, I just terminated her for this reason. What else do I have to do to make sure that I've covered myself for HR purposes? Then she immediately called her opposing counsel and said what happened and asked for an extension of time. And then she also called the court and reported to the court what had happened, because she wanted to make sure that if in 2 years that document turned up with her improper notarization, it wasn't going to be a problem for her and for her license. So it was only because she was supervising everything that was going on in her files that she found this, and she found out something unethical had happened, and she terminated the person right away. She reported it to the tribunal, to the court, and she reported it to opposing counsel, asked for an extension, and she took care of it. But that is a serious concern. There were no attorneys around. Her notary stamp was in her drawer. She doesn't keep it in her drawer anymore. She keeps it in her purse now. And it was, it's a serious, that was an eye opener for her too. And she said it was too bad for her and for her support staff member, because she would have come in. The girl didn't have to take the notary stamp. The girl would have come in, the attorney would have come in. So that's something, it's a kind of a scary story, but it's a good point for why you should be supervising things when you're not there to make sure things are happening. You got to check and you got to watch the people that are under your supervision. Next, we have the unauthorized practice of law. This is one that I said I kind of hope applies to some of you guys in one way, because not only because it'd be really great if we were back this kid's age and got to dress up in your dad's suits again, but it's kind of if you're out of state. So I'm picturing unauthorized practice of law. If you're sitting in your bungalow in Florida right now, but you're practicing on your New York cases. So if you're not admitted in Florida but you're practicing in about the cases that you're admitted for New York State, that is okay if you're remote working, but you're not working on Florida cases. You can work on New York State cases outside of New York State. And there is an ABA issued opinion, it's 495, on the unauthorized practice of law in working remotely. So my big takeaway from that was, if you are working from that beach house, you can't hold yourself out as being able to practice in that jurisdiction in Florida if you can. So don't hang up a coconut and paint it that says Liz is a lawyer and hang it up on your beach house out there. Just work inside, go outside, have your margarita, and be done for the day. It would also be tempting to take up a case if you're sitting in Florida and your neighboring bungalow comes up and says, hey, I've got this guy, he just keeps jumping on my bill. Can you help me collect from him? Will you just send him a letter as an attorney and collect? I won't ever charge you ever again when you come to my bar. Avoid that temptation. That would be practicing in Florida and you're not admitted in Florida. That'd be the unauthorized practice of law, and that would be against Rule 5.5. So remember, even if you're practicing, if you're sitting in sweatpants in a different jurisdiction that you are not admitted in, you can only practice law in the jurisdiction in which you're admitted. So there's a lot of opinions out there. It's actually been kind of a big deal for big firms during the remote work time, virtual work. They've rolled out a lot of opinions for their associates and for their staff members too. So there's some other pitfalls from working at home, and this is something that I've seen more in talking to people than I've seen online in my research. And some of it is people were working from home. They would wake up in the morning, take a shower or not, put on their sweatpants, put a little Bailey's in their coffee, and then put another little Bailey's in their coffee and put a little bit more Bailey's in their coffee. Well, you're not doing that at work. By 1 o'clock, you're a little tipsy, and you're like, well, you know what would be nice with lunch? A beer. So then you have a beer, you have another beer. You can't be drinking at home and practicing law and think you're still competent and you're still a competent attorney and you're still properly representing your clients. There has been a lot of discussion about people drinking or people taking other recreational drugs at home because it's tempting, it's there. Remember, you still have to be a competent attorney. You still have to be diligent in representing your clients. Sweatpants don't count as being incompetent as an attorney, I don't think, unless we'll see what the judges say when they talk about virtual court proceedings and the proper attire. I think if you don't stand out, they can't tell the difference. But that's black leggings are my go-to because they look they look just like suit pants, but we'll see what the judges say. But avoid those other pitfalls. Make sure that you are sticking with happy hour and you're not practicing after you drink. Another big thing that I've heard a lot of people talk about, and it was tough for some of the less experienced attorneys was, especially on the defense end, was fudging hours. So we go by the billable hour, and you have to hit so many hours. Well, it's a lot easier when you don't have to clock in at 9 and clock out at 5 to say, well, this motion didn't really take me 3 hours, but I really want to watch Netflix. There's a really good new show coming out, and I'm just going to lay on the couch for an hour and say this motion took me 3 hours. And well, they don't really know that I wasn't working all day long. I'm just going to pretend I was working all day long. As long as I'm on my phone on Microsoft Teams, they won't be able to tell the difference. It's funny how many people really can tell the difference and really can tell when an attorney or a staff member is not actually working. So there's been a lot of problems with what it really comes down to is fraud. And that is a common pitfall that has been discussed a lot around more inexperienced attorneys, for sure. And that is something that should really be avoided and is a dangerous pitfall too. So now, I don't know if anybody remembers these books, but there was like Calamity Jane and Babe the Ox. These are from when I was little, and I was so excited to find this little picture. So now I'm going to talk about some of the tell tales and the scary situations that everybody loves to hear from the grievance committee. So the first one we have, this is an Arizona case, and this is one that I have to thank Peggy Callanan for. This is where a lawyer was from Arizona, was suspended for coaching a client using the chat function during a virtual trial, an actual trial. So there was a trial. You guys are going to love this. There was a trial during a divorce proceeding, and this client's this attorney's client was on the stand and being cross-examined by her husband. So the attorney was not there. The only person in the actual courtroom was the judge. So the attorney and the client are both at home. The attorney starts chatting in the GoToMeeting chat and telling his client specific examples and specific answers, substantive answers to questions. So her husband was cross-examining her. The attorney was typing up how to respond, and she was responding exactly what her attorney was saying in the chat, but she was saying it out loud. So the judge saw that chats were happening, opened up the chat, and saw that he was feeding his client all the answers. So there's a lot of ethics issues here. First of all, he obviously wasn't competent enough to realize that the judge could read his chats. And there's also fairness to opposing counsel or opposing party there, because the estranged husband was not represented. It's fraud, basically. Well, fraud, deceit, or misrepresentation. And it was conduct prejudicial to the administration of justice. So the judge told the attorney to stop. The attorney said, okay, I will, but really it's the same as if I was just shaking my head yes or no to my client in the court. That's what he told the judge during the proceeding. So of course the judge reported him to the ethics committee, and he consented to a 2-month suspension. And he was a young attorney. He's only been in practice for a few years, which is part of why he only got a 2-month suspension, but he still was suspended for 2 months after coaching his client, basically, on the stand. So that's just one of the pitfalls. Now, it's something that you could easily fall into, and we'll get into a couple more examples of this, because I gotta say, attorneys, we're crazy, because there's another one that I've got that you guys are going to find even crazier. This one's a Florida attorney, and this is a really weird situation. It was actually pre-COVID, but the decision just came down about his suspension a couple months ago. So there was a deposition being taken and nobody is in the same room together. And even the court reporter wasn't in the same room. And it was a phone only deposition. And the court reporter refused to swear in the witness because it was by phone only. So it was going to be an unsworn deposition, which I guess it's really just a discovery deposition at that point. So as the witness is being questioned, the questioning attorney can hear like this little click, 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 click sound. And the questioning attorney says, "Hey, are you two text messaging?" And the witness's attorney says, "No, I'm just texting my daughter." And the questioning attorney says, "That's it. We're not going to be doing any more deposition right now. I'm going to get your text messages." So the questioning attorney stops the deposition, files a motion to compel these text messages from the questioning attorney or from the producing attorney, and files in-camera inspection of all of the text messages that this producing attorney gets and sends during the time. So the judge gets all of the text messages, and the judge determines there's a bunch of messages, like 3 pages of messages. None of them were sent during a break in the questioning, and they're not protected by attorney-client privilege. And there was a disciplinary proceeding where the producing attorney testified he couldn't retrieve any of the text messages from his daughter, and I'm using air quotes for any of you that are just listening, because of his own technological limitations. But he really felt like, so he was texting his client, and he felt like he had to text his client because the questioning attorney was being unfair in her questions and his client was being mistreated. So he had to give her some of the answers. But he wasn't really forthright in the initial judge, like the trial court judge, when he asked about the text messages. He kind of lied. He made it appear that he had only texted his wife and his daughter, and he only sent text messages to his client during the break. So the disciplinary counsel that they had, they call it bar counsel down in Florida, I think, they were not happy with him at all. First of all, they granted him, they granted bar counsel $2,850 worth of costs for just even having to bring the disciplinary proceeding. They also, bar counsel, a referee had recommended a 30-day suspension, and they said it wasn't high enough. The Florida Supreme Court actually then had a 91-day suspension instead of a 30-day suspension because they were so mad at this guy. And the attorney for the bad attorney, I'll call him, said in this article that I read that this case is a wake-up call, that attorneys can't demonstrate less than the highest standards of conduct, even in informal or electronic proceedings. And that's pretty, I don't think it's a wake-up call. I think it's somebody just kind of trying to cheat. Let's call it cheating. So I will talk about one of my own cases that I have a very similar situation that just happened in, I think it was September of last year. So it was actually an associate of mine who's very smart, one of my associate attorneys, and we had a co-defendant attorney, and they were asking a plaintiff, they were taking her deposition. So at one point she asked to go get coffee, and she went and she came back, but she didn't have any coffee. So my associate said, "Where's your coffee?" And she said, "Oh." And he said, "Did you not make coffee?" And she didn't really have an answer. And he said, "So what were you doing during the break?" And she said, "I was on the phone." And he said, "Okay, well, who were you talking to?" And she said, "I was talking to my attorney." And he said, "But your attorney's there with you. Who were you talking to?" So it came out after extensive questioning, that she had called a different attorney that didn't even represent her in this case to talk about the deposition that was happening. And she also was text messaging her brother during the proceeding. So we obviously stopped. We asked questions. We tried to get information on the discussion she had with her attorney. And we asked for her to read out the text messages with her brother that were pertinent to the case. He was not a party. The attorney that was producing her refused. So we had to make a motion to compel. So we made the motion and the judge didn't decide it, but we had a pretrial conference and we were talking it out. And the judge said, well, to the plaintiff's attorney, well, I think you should know that if this motion goes through, I'm going to fine for the defendants. So maybe before I make the determination, you should just voluntarily produce everything. So they produced 7 pages of text messages, but redacted a bunch. So we found so many pages of text messages. She was asking her brother what her mother's doctor's name was, because we had asked her that during the deposition. But we also said, if you don't remember, it's okay. This isn't a memory game. Just tell us what you remember. So then we went back to the judge and we said, Judge, we think we'd like to know what all these redacted text messages are. And the other attorney said, no. And we said, we want to know. And so then the judge said, well, I have an unredacted copy. Let me look. And he said to the plaintiff's attorney, really? This is what you're redacting? And so the judge read some of it out. It said, boy, I can't wait for wine. Is it almost wine o'clock? Yep, it's going to be wine o'clock soon. And then one of it was a comment making fun of the co-defendant attorney, that they were just trying to save his feelings, just saying that he was basically a jerk. So those were the redactions. But that is one of it goes back to Bridget and her saying, you should prepare your client for an ADR. You should really prepare your client for a deposition also, and tell them you probably shouldn't be text messaging your brother and making fun of the attorneys asking you questions, because they're probably going to get copies of those text messages also. We also were entitled to ask her questions about the discussion she had with the other unrelated attorney. And the judge verbally decided that, and we haven't had that deposition yet, but it was an attorney that has nothing to do with this case. So the attorney-client privilege doesn't apply for this matter, and she was talking substantively about our case. So that happened. It's so perfect for this case that I wanted to go over that one too. So we have a lot of technology issues that have been circulating around, mostly text messaging. There's been a couple other cases. I will never produce a witness when I'm not sitting there with them. And I also will not have a deposition where another party and their witness are present without me being there, because we've seen other instances of them writing notes to each other when you're not in the room. I think that is conduct unbecoming of an attorney. I think there's a few other rules that also apply to that as well. And I think that unfortunately, in times of COVID, people have gotten a little lax about their ethical rules and what you can and can't do as an attorney during these virtual proceedings. And I always, if I am having a deposition and there's going to be more than one party, I ask in advance who's going to be where and who's going to be with whom, because I will then make sure that I am with the witness and their attorney, or the most people that are going to be in the room. And I'll also ask that they all be on the screen also, and set up things, because it's sad what has happened to some of the attorneys. I won't say all of them. A few choice attorneys have really taken advantage of some of the technology these days. So next screen. Sorry, I lost my mouse. Okay. So always remember, no matter what you're wearing, whether it's sweatpants and Uggs or your real suit and you're actually in the courtroom, or where you are, there's ethics rules that have to be followed. You owe a duty of competent representation to your clients always. And you have to act with reasonable diligence and promptness, even when proceedings are moving slowly or the courts are closed. You have to keep your clients updated. You have to make sure that they feel like they're being heard, and that even if the court isn't moving, that you are doing something to advance their case, even if it's just talking to them, sending them an update that says there are no updates, and telling them in some way that you're still their lawyer, you're still looking out for them. Confidentiality has to be a serious consideration. Make sure, like Bridget and Keith said, if there's isn't going to be a room for your client where they can be completely confidential during a deposition or during a hearing where there might be other people around, bring them to your office. If you are COVID concerned, have a special office just for them and tell them about your mask policy. They don't have to be in the same room as you, but they do need to be in some place where you can be completely confidential and keep everything completely confidential. Supervision might be difficult during virtual times, but it is important as always. It might even be more important now when you can't just pop your head in, or younger attorneys or staff members can't just ask you a quick question. They also sometimes are scared to call you up if you're at home and they're at home. They might feel like they're bothering you. So make sure that you are reaching out to them and saying, hey, do you have any questions? And then you'll be surprised how much the floodgates open when you reach out to them and you extend that hand and that olive branch. Watch where you're practicing, or where people think you're practicing. If you're in Florida and you're telling them you're a lawyer, make sure you say, but I'm not in practice in Florida. Actually, my cousin who lives in Florida just texted me this morning and asked me about something. And I said, I don't know the Florida laws, so you're going to have to ask somebody else. I said, or go ahead and Google it, be your own lawyer, but I can't give you any advice on that one. So make sure that if you are not here, but you're practicing law, that you are only practicing laws in the jurisdiction in which you are actually licensed to practice. And I always tell people whenever I do any kind of presentation on ethics, trust your gut. If something feels weird, it's probably weird. It's probably not right. You probably shouldn't be doing it. Most of us attorneys have good guts, so follow that gut. I can't tell you how many times people have, we hear people, heard people in the grievance committee, or people come to me and they say, you know, I didn't know what I was doing, or I shouldn't have taken that one. And then it turns out to be a bad thing. So make sure you're not doing that bad thing and you're not taking that bad case that you shouldn't, or you're aligning yourself with people that can help you and can help you be competent and diligent in your practice. So Sarah, I know I started a little bit early, so let me know if you need me to talk any more, but I think I'm right about on time.
Yeah, thank you, Liz, so much. That was very informative, and the stories were very entertaining for sure. Okay. We have one question, and if others don't come in, if we don't get any additional questions, if you have any other stories that you can think about, that you can feel free to share with us. If you have any additional ones. But the question that was posed in the chat, virtual scenes are new, but phone calls and conferences have been around a long time. What about passing a note to a client during a call? And you touched on that a little bit, I think, but if you could expand on, is that permissible? Is that not permissible?
I think that if you're talking about passing a note during a call, like during a deposition or something like that, that is, as long as I feel, if it's something that your opponent sees you're doing, that's one thing. If you're trying to be sly and hiding about it, and it's not out in the open, they can't see you kicking your client under the table, or in the Arizona attorney where he was suspended, the opponent can't see him nodding or shaking his head. I personally think that's a little bit of a different story than passing a note and nobody knows that you're doing it. Like at a deposition, you take a break, you go out in the hallway, you and your client are whispering, you come back and the other attorney says, I just saw you whispering in the hall with your client. So if you're trying to be shady about it, it's a different story than if other people can see that you're actually doing it.
Thank you, Liz. That was the only question that came in the chat. Are there any other stories that you want to share with us?
Oh, there's 100. So I do. But I think, I know there was actually a couple other ones that I actually, around notarization, that I think are really important for people to be cognizant of right now. When you are notarizing, because most of us as attorneys, you can be a notary public. I know that some people haven't done that. Make sure that the person, my husband actually would love this story, because he asked me to notarize something for him and I made him show me his driver's license because that's a requirement. So he said, are you actually going to Zoom with me and make me show you my driver's license? I said, yes. And then I said, are you sitting in the state of New York? And he said, oh my gosh, I'm not coming home and making you dinner tonight. But it's required of us under the rules that we have to make sure that we see valid ID. Well, that part I was being a little bit silly because I am married to him. But you also have to make sure that they are actually sitting in New York State at the time. So if you're notarizing somebody through Zoom or through some kind of video, and you are actually attesting that, yes, that person is who they are and that they are sitting in New York State, I recommend that you actually look at their driver's license. I mean, I know Sarah because Sarah and I have known each other since you were like a 1L in law school. But I don't know some of the other people. If Michelle told me she was Michelle, I've never seen her face before, but we've corresponded through email. But I would say, Michelle, can you show me your driver's license? And are you in New York State? And I'd say, sorry, I have to say this, but my license is on the line. And it's kind of an issue because we actually did see my last year in the grievance committee, an attorney that had an issue come before the grievance committee because of his notarization, believe it or not, because he had notarized something, and then like I said at the beginning, one little thing happens and somebody sees something weird with your notary stamp, and then the whole house and the whole cookie start to crumble. They're like, oh, how does that happen with your notary stamp? That's weird. Wait, now I'm going to look into this guy. Oh, wait, his attorney trust account isn't up. Oh, wait, he hasn't been licensed to practice in a year. Oh, wait, he owes us all of this money. Now he's coming in front of the grievance committee and having to talk to us about 6 violations. And it's a scary thing. So don't let you notarizing somebody who might actually have been in California during that time, and their ex-husband knew they were in California, but you said that they were in New York State, so now they want to come after you because they're vindictive. Don't let that be a reason that all of a sudden you are being reported to the grievance committee. How's that, Sarah? Good
that was
enough?
very good. Thank you, Liz. Carisha, if you could give us our 3rd course code, and after that, we're going to take a brief 5-minute break just so folks can run to the restroom if they need to, grab something to drink. We've sat through 3 presentations, so I think folks need a couple minutes to stretch and get something.
Yes. So I will give you our 3rd CLE code, and then we'll take a break and be back at 11:50. Our 3rd CLE code is grievances. Our 3rd CLE code is grievances. Again, that will be in the chat. Grievances, we will take a, now 6-minute break, and we will be back at 11:50 to wrap up our sessions with our wonderful justices.
The time's 11:50, so hopefully everyone's back. Carisha, if you would like to go ahead and introduce Justice Martocci and Justice Nowak.
Yes, I just wanted to confirm, is Justice Nowak on the Zoom call? Or is he with you, Judge?
Hi, everybody. You know, he was finishing up special term and he told me that he might be running a few minutes late. So I don't know that he's on. In fact, I messaged him. I don't think he is yet, but I'm certainly happy to start whenever you want us to start.
Perfect. So I will do the introductions and hopefully he will pop in then. And if not, we can certainly start until he joins. Okay, everyone. Hopefully everyone is back. It is my pleasure to introduce our next speakers. First, I will start with Justice Amy Martocci. Justice Martocci is a New York State Supreme Court Justice elected in November of 2020. She formerly served as a Buffalo City Court judge, where she founded and presided over the Human Trafficking Intervention Hub Court from its inception in 2013 until she started her new role in the Supreme Court. Mayor Byron Brown appointed Justice Martocci to the Buffalo City Court bench in 2011. She was then elected to a 10-year term in 2012. Prior to becoming a judge, Justice Martocci worked in private practice and also served as a confidential law clerk to the Honorable Frederick Scullin Jr. in the Northern District of New York. Justice Martocci received her undergraduate degree from Cornell University School of Industrial and Labor Relations. She's also a graduate of the University at Buffalo School of Law. Justice Henry Nowak was elected to the New York State Supreme Court in November of 2010. Since then, he has handled a wide variety of civil cases as well as commercial and matrimonial matters. Justice Nowak also served as a Buffalo City Court judge from 2003 through 2010. Before being elected to the bench, he was a trial attorney in Buffalo, New York, in private practice. Justice Nowak received his undergraduate degree in biology from the University at Buffalo in 1990, graduated magna cum laude, and as a University Honors Scholar. He continued at the University of Buffalo School of Law, where he served as the publications editor of the Buffalo Law Review, graduated in 1993. He's a regular instructor at the New York State Judicial Institute and currently serves on the board of the University at Buffalo Law Alumni Association. I will turn the floor over to you, Justice Martocci, to begin.
Thank you very much. I appreciate it. First of all, I just want to thank the speakers who went before me. You might hear some overlap in some of the things that Judge Nowak and I are going to talk about. Frankly, because there is overlap, and this virtual world has different nuances depending on where we're appearing, whether it's for a mediation or for a deposition or in court. So some of the things you're going to hear, you've probably already heard, and I'll be reiterating maybe what Liz or Kevin or Bridget already said. And there are some differences for sure. So I always like to start these things with a bit of levity. And this is one of my favorite things from the virtual world of virtual court during the pandemic. If you haven't seen it, I can't imagine you haven't. You're in for a treat. And if you have seen it, I think you'll like it anyway. Okay, well, I think we're gonna have to skip over that one because it is apparently not working. I apologize. I cannot figure out how to share the audio. I haven't had this problem before. In any event, this is part of the problem, I guess, with virtual court appearances and virtual appearances in general. The technology is not quite working. I'm going to go back to the next screen. This was a situation where I think the attorney's daughter had put a filter on his computer and he was not able to figure out how to take the filter off. I'm going to skip to the next slide. And so the next thing we want to talk about is how rules apply to virtual proceedings. And so certainly the first thing we want to talk about is, and now I'm sharing the wrong screen. Oh boy. So bear with me for just 1 second. Okay, So we're going to talk about the rules that bear on virtual proceedings. And first and foremost, we want to talk about the rules. Competent representation requires legal knowledge, skill, and thoroughness and preparation reasonably necessary for representation. So that's 1.1. And then 1.3, a lawyer shall act with reasonable diligence and promptness in representing a client. And certainly that means becoming familiar with the virtual platforms that you're required to appear on.
Judge Martocci, if I could jump in also. Sorry that everyone, I just finished special term, so I'm sorry that I got to the presentation a little bit late. But I think that what we'll be kind of talking about throughout the presentation, those two ethical rules, competency and diligence, as to how does that now affect your ability to present remotely, both for yourself, certainly for your clients, or in hearings or in oral argument. And I think the burden now is placed on attorneys to do much more in terms of technology than was previous. I think that the competency and the diligence rules now require that. So it's something that I think you need to plan for and think about a little bit more. And Judge, I can sort of jump in on this slide too. In terms of, we wanted to start with talking about just conferences, regular conferences. Everything I think is, every conference I always consider to be a pretrial conference, but I characterize my conferences as compliance conferences where you're trying to see, are you in compliance with the scheduling order? Lots of status conferences, settlement conferences. I have a thing called the calendaring conference, which is really just to select a trial date or send a case to mediation. But regardless of what type of conference you have, the one thing I think that all the attorneys should do is appreciate from the judge's perspective as to how virtual conferences are different from the live conferences. And really, we're not as much fans, I think, as the attorneys are. And so I have a couple of examples of the differences that I see personally between live and virtual. For live conferences, when we used to do that, when people used to come to our offices, you can imagine what happens. I'm back in chambers waiting for the conference. The attorneys come in, check in with my secretary, and my secretary will say, all right, go to this jury room or go to this conference room, waiting for opposing counsel to come. If there's any problem, if somebody's not showing up, they didn't have it on their calendar, all of that's done without bothering the judge. I'm back working on decisions or doing something else. Meanwhile, my secretary's doing all the scrambling. And so basically the first word I get, either by phone or a knock on my door saying, they're ready for this conference, and stand up and walk right into the conference. So the preparation stuff was not done by the judge ahead of time. Now it is. Now it's not uncommon where I'm the first one in the conference on virtually, and then only one person or sometimes zero people are there, and I have to start chasing down the individuals. And I don't know, Judge Martocci, if you do it any differently. I've had times where I've asked my secretary to do that, where she enters the room and tries to find everybody first, but it's almost easier for the judge to do it, but yet more time consuming. Judge Martocci, what do you do?
Yeah, I mean, it has become more arduous, I think, for the judge. Even in years prior, where there would be a phone conference set up, generally the secretary would do the gathering of the parties. The secretary would call the parties, conference them in, and then you'd get the phone call, everyone's here for your conference call. But again, given the differences of doing it virtually, we really have become the gatekeepers, and we've also become the people chasing other people around. It becomes a little bit difficult. Everybody is on the Zoom and the Teams, and you're waiting for one more person. Now, how do you track that person down? I certainly know that in years past, people didn't text one another, but almost everybody, lawyers, have my cell phone number now, and they'll text, I'll text them, where are you? We're waiting for you on this meeting. And so it has become a little bit more difficult, I think, in terms of, getting everybody in the room.
it's funny that you mentioned that. I've assembled, I have right in front of me. It's the first thing on my desk, my list, my cheat sheet. It's like 6 pages now of attorneys' cell phone numbers, which we keep because I refer to it constantly. It's the most referred to document on my desk because we're just trying to get these things done. The other thing that I've noticed with conferences now, and this is true mostly for like compliance conferences, if I have a deadline, a scheduling order, and the deadline says EBTs are supposed to be done by this date, and then you have a conference a week later to see where are we going to go, how do the EBTs go? Is it ready to settle, or should we go to mediation? In the past, if EBTs weren't done for whatever reason, couldn't get them done, couldn't get them scheduled, somebody had a problem and you couldn't get them done, the attorneys wouldn't take the trouble of coming to court, parking in the ramp, going through the metal detectors or going around with your ID, coming upstairs. They wouldn't do that to report we didn't get the depositions done. They know that nothing's going to happen, so they wouldn't want to go through the effort. So what they would do, of course, is call the secretary ahead of time and say, hey, we didn't get the EBTs done. Can we have 30 days, 60 days of an adjournment to get done what we were supposed to get done by today? Because otherwise we're all wasting our time. So I wouldn't even know. All I would know is, oh, what happened to that conference? Oh, it was kicked off 30 days, 60 days. They're finishing EBTs. Great. I'm going to work on something else. Now, those conferences are happening because it's so easy because you're at your desk and you can just log in and report. But for me, that's a whole bunch of these unnecessary compliance conferences where all we end up doing is extending out scheduling orders or something like that. So pay particular mind. I mean, we'll talk about sort of do's and don'ts with conferences, but pay particular mind is if you don't have anything really to report, then you might want to consider adjourning it, even though it's an easy virtual conference from your desk. Judge Martocci, are you finding the same thing?
I am definitely finding the same thing. And I think that brings us into the next point, which is really use your common sense when we're doing virtual appearances, whether it's a virtual hearing or a virtual conference with the judge. There is certain etiquette that we are expected to understand. Don't eat when you're doing a hearing. Drinking a glass of water is one thing, but we don't want to see people driving through and ordering their lunch, which I don't know if you've had that happen, Judge Nowak, but I have. During a virtual hearing, can you hold on for a minute? I'm driving through and I need to order something. Or you also realize that a lot of people don't understand the mute button. When you're not speaking, it's part of the virtual etiquette that you need to mute yourself. I don't want to hear you flipping through papers because I can't pay attention to everything that's going on. So these are really basic etiquette rules for the virtual context. Judge Nowak?
Yeah, I think that's true. And, and try to think about, your eyes. I mean, right now I'm focused on my camera, but I find that even in a presentation like this, I often I was just looking at Judge Martocci, and I often look at myself too when I'm speaking, which I think everybody does. So if you can, I have Judge Martocci's image on my screen right now, just below the camera, and then I'm next to it. So if you can move the pictures around, and there's gallery settings and different settings so that the people that you're going to be focused on are at least close to the camera, because it is hard to force yourself to look at the camera as you're talking, but try to get the images as close as you can, because again, that's, I think, a little bit more respectful to the parties. I think it makes a better impression. So that's just an additional tip.
So next we're going to talk about, in terms of conferences, what we say are do's and don'ts. So Judge Nowak, take it away.
Well, yeah, I mean, the first one I've already kind of beat the drum on, again, and requesting the adjournment if there's no purpose, and then be on time, because you know that the judge is probably going to be the one, or even the law clerk, but whoever's running the conference is going to be the one to try to chase people down, because it's an effort to just simply adjourn it. We want to at least, touch base while we've made the effort. Be prepared, know what happened at the last conference. What I do now is that I typically will make my notes contemporaneously with the conference, and I do it actually right in the calendar entry on the computer, so that as soon as I'm done with the conference, I report exactly what happened at the conference, because sometimes it'll come up, it'll say, oh, gee, didn't you say this? Didn't you say that? So my notes are now done contemporaneously and by the computer. I don't have to rifle through paper and look for a paper note anymore. It's not uncommon now when I have a subsequent conference to have an attorney tell me, oh, judge, here's where we are in the case. And I'm reading it almost word for word from my notes from the last conference. Like, well, wait a second, there's no progress here. So, keep that in mind. I think a lot of judges and law clerks have a system similar to that where, we know what you said last time. So it's just, note that there's progress. And again, if no progress, it's okay. It happens. I mean, I practiced, I know what it's like to say, oh, gee, I got busy. We weren't able to do what we thought. I still owe discovery responses or whatever. But that's the time I think you want to, the day before, adjourn it, request an adjournment. If the judge, and I know every judge is different, Judge Martocci, tell me what you do. But if the judge says, no, I want you here, I want to check in, even if you haven't done anything, fine. At least you tried. At least you show the respect and you say, gee, I didn't want to waste your time. I'm happy to report that it's my fault, mea culpa, whatever. But I don't like the inefficiency of it. Judge Martocci, what about you?
I find that when someone is asking for an adjournment for that reason, they are generally telling me what the plan is to move the case forward anyway. They'll say, the depositions didn't happen, but they're scheduled for 2 weeks from now. Or the home appraisal, we had a problem getting the home appraised, but it's going to happen on such and such a date. We'll have it back in 3 weeks. It would make more sense to come back after that. I mean, I do think those are the best kinds of adjournment requests where someone says, here's where we are, not as far as we should have been. Here's what we're going to do to move the ball forward. We're requesting 30 days. And, one thing I will say is if you're requesting an adjournment, please contact opposing counsel and ask for their consent to adjourn something. Let us know that up front and suggest some alternative dates that you and your opposing counsel are able to appear. It really helps things for us to know that you've communicated and here's when we're available so that we can take a look at the court calendar and slot something in right away. Judge Nowak, what do you think about that?
Yeah, that's a great point. Yeah, that kind of goes without saying. When I say request an adjournment, it's always after you spoke to opposing counsel, you get an agreement, you do it together. That don't do anything on your own that way, because then opposing counsel may very well have an issue with discovery that they need to present to the court, address, or something like that. I also have the note. The last do that I have on this list is request separate calls. I've actually set up separate Teams links because I've struggled to find the breakout room feature on Teams for many of my conferences. It's easier to find for Zoom than it is for Teams, but we use Teams. And when I've found it, it works okay. The breakout feature works. But if you're going to have settlement conferences, think in advance. If you want to go, one room, another room, what we used to do when it was live is put one in a conference room, one in the jury room or something like that, and talk to each of you individually. It's a great tool, but it's hard to do with the technology unless you plan for it in advance. So if you think that's something that may be helpful for an upcoming conference, suggest it. And then the court or the secretary can try to facilitate a way where I've had, somebody say, you come in the Teams room at 11, you come in at 11:30, and I want to talk to each of you individually, and you kick the other person out. So there's ways to do it. You just need to kind of plan. And then I have for the don'ts, don't do it from your car is sort of a pet peeve of mine that drives me crazy. And then the last one is one that applies, I think, to whether it's a live or a remote conference, is always kind of have a goal in mind. Know what you're hoping to get out of the conference. Even if all you say is, look, we're not going to resolve this, we need a trial date. Great, better to know that sooner so I don't waste 3 conferences trying to settle a case that can't be settled or won't be settled unless we have, an IME or something else that kind of gets us to the next stage.
And I guess I'll just jump in here because one of the things you jumped over was a reliable internet provider. I think we've been on virtual appearances with lots of different lawyers, and most people have figured it out. They've figured out the glitches, but there are a handful of people who always have unreliable internet. It's not a one-off, it's continuous. And I would just say this, it's a tricky area, but there are groups and, Jack Hunt and others that can help you get your office set up so that you've got reliable, fast internet that can handle the virtual appearances. I mean, I know sometimes I'll have to say, well, turn your video off because you keep glitching and we can't hear you. And if you stop the camera, it doesn't take up as much bandwidth, I guess. But it's really important if you don't have good internet, reliable internet, to try and make that, to try and fix that. So
Judge Martocci, do you mind at this point, before we go into the next one, if we open it up to any questions about conferences? Because I think we're going to move on to pretty soon into hearings and other types of things. But anybody want to share experiences you've had maybe with other judges in terms of conferences, things they've done well or things that didn't go so well that you had a question about, or anything about that we've said? Anybody can use the raise your hand feature or post a question in the chat. Not yet, not yet. All right, feel free to interrupt Judge Martocci or me as we go along, either to share an experience similar to what we're talking about.
Justice Nowak, I see Liz's hand is up.
Oh, hi, Liz. Yep, thank you. Great, jump in.
Judge, some of the parts are doing like email check-ins for pre-trial conferences, and I found that that's helpful for us. They're not doing actual pre-trials. They're just saying, hey, I'm going to check in with you guys by email in 2 months. If you think we need a real pre-trial conference, let us know. Otherwise, I'll just shoot you guys an email. That has really been helpful to me because it's still holding us responsible. But sometimes, for instance, my nursing home cases take 153 years roughly to, get all the way through. So it's making sure it's holding my feet to the fire. But at the same point, you don't have to make sure you're getting 6 people on the call, and that it's not wasting judicial resources at the same time.
That's a nice idea. I haven't done it yet. Judge Martocci, do you do that?
No, I haven't either, but I think I'm going to employ that tactic. I think that's a great idea.
Thank you
for sharing, Liz. And I'm looking at the chat. I don't see anyone else in the chat with any questions, but at any time, raise your hand or send us a question. It's better for us to have a dialogue. So we'd welcome any questions or comments along the way. I know it's funny, we're talking about virtual protocol and I couldn't get my sound to work. I do think I've fixed it. So let's see, I'm going to play another clip, because this is something that I think many people who are parents have struggled with during the pandemic, to try and make sure the doors were closed. Here we go.
Scandals happen all the time. The question is, how do democracies respond to those scandals?
And what will it mean for the wider region? I think one of your children has just walked in. I mean, shifting sands in the region. Do you think relations with the North may change?
I would be surprised if they do. Pardon me. Pardon me. My apologies.
What's this going to mean for the region?
My apologies. South Korea's policy choices on North Korea have been severely limited in the last 6 months to a year.
Right. So, I mean, who of us hasn't been there in some way, whether it's a dog barking or a kid coming in the room or a delivery person or whatever it is. But I would just suggest, again, now that this is the norm, we have to really think about how to make sure it doesn't happen, or at least give it some thought. If he'd locked the door, he was interviewed, this reporter, after this happened. He was sort of famous for the moment. And he said, I always lock the door and I forgot to lock the door this time. And you could see the whole family joined in. So that's one of my favorites.
Yeah, it's trying to keep control of your environment as best you can is something to keep in mind, even if you are working from home or remotely, to have that designated space where you have a little bit. And yeah, I mean, I try to be as forgiving as I can, and certainly during the pandemic we were. But again, to the extent that you've had some time to think about it now, do what you can. Everything else this person has on screen is perfect. I mean, just the background, everything's fine except for just the locked door. So anyway.
So now we're going to shift to talking about
scandals happen all the time.
When we're on the record, oral argument and hearings. And so again, some of these things we've already talked about. Enter the room on time. even if your case isn't going to be the first case called. Now, I know when I was doing solely matrimonial cases, I didn't have other people entering the room. Those are private proceedings, only accessible to the parties. And so we didn't have a lot of people in the room at once, only the people who were participating in that proceeding. And we would schedule on the half hour, 9, 9:30, 10, 10:30. But Judge Nowak, I know that's not how you do it. So why don't you jump in here?
Yeah, so what we've tried to do is I've tried to facilitate, tried to make it look like it used to be live when we were in the courtroom. So it's just the same as when everybody kind of enters the room. I either have a 9:30 start time or a 2 o'clock start time, and everybody's in the room, and then we call the cases one at a time. And I'll ask the attorneys to mute and to turn off their cameras until your case is called, the same as if you were walking forward at the bar. The reason why we switched to that format, first of all, it seems like it's working well. Second of all, I don't think that it's too cumbersome for an attorney to, when their mic is off and they're waiting for their case to be called, to do a little bit of other work, or at least review what you're going to say when your case is called for oral argument. My oral arguments, I tend to really try very hard to read all the papers and have specific questions for the attorneys. So I think it's worthwhile for the attorneys to sort of look over their papers, look over the notes that they may have for argument anyway. So I don't see it as really cumbersome to make people wait. And what I found is that when I was scheduling them on the half hour, sometimes they're done in 2-3 minutes, where the attorneys will come in and say, well, we've worked this out, or we have, this thing resolved. And then I have 28 minutes until the next conference. And then, oftentimes things adjourn at the last minute. And the other thing I found is that sometimes when you have a really thorough oral argument, a half hour is not enough. And now I have another one coming up, and I'm trying to scramble and finish up an oral argument and force people to finish, where I have more questions and they have more to say, and you have multiple parties. And this was especially true when I was doing commercial cases, and I still have some, where you might have, motions and cross motions on, 5 different causes of action that you're trying to grapple with. So this way it's better. And I can certainly call the cases in the order of the ones that I think will take the least amount of time to be as efficient as possible. So if I get that one 45-minute oral argument, that'll be near the end, so that I don't have everybody waiting for that one. So that's the way that I do it. And so far it's worked out really well. Any questions about that? No? Okay.
And, next, we've already talked about this somewhat, but make sure that you appear with a camera. Especially when things are on the record. It's not fair to a court reporter to not have the opportunity to read your lips. When we're in person, a court reporter looks at what's being said as much as he or she hears it. So you've got to make sure that your camera is on and that it's a clear microphone to make a record.
Yeah, that's even more important than for conferences. We have phone conferences. It's easier you can get away without having a camera there, but not for oral argument. Can I go back real quick? Just the one thing about entering the room on time for hearings. I've already griped about how it's frustrating when you don't do it for a conference. For oral argument, if I have a group oral argument and we start an argument and people are arguing, and then I see a note, it'll pop up that someone's in the lobby. That's coming up for a case that I haven't called yet, which is okay. I generally let them in the room immediately, because if I don't, what I find is that they'll call my secretary on the telephone saying, I'm waiting in the lobby. Is there a problem with the link? Are we not doing it today? And then my secretary comes and knocks on my door. That's worse. So what I'll do is I'll let them in the room. So then they suddenly, in the middle of the argument, a new attorney will appear, microphone on, camera on, interrupting the argument, and I can quickly mute them, and I can even disable the camera on my end, but it's a little bit of a disruption. And then actually getting the camera back on when it is their time for their case is another little hurdle that we can get over, but it's a pain in the neck. So really try to be on time, even if all you're doing is checking in, muting, turning off your camera. At least you're there, and then we don't have those interruptions.
And to that point, Judge Nowak, sometimes attorneys will have their clients with them if it's an important oral argument, or if it's a hearing and there's testimony that's going to be taken. Right. But I always tell attorneys to let their clients know I always have an attorneys only conference to start off every hearing. So it may be that the parties themselves are in the waiting room for 15 minutes, 20 minutes. Let them know that that is normal, that we're doing the court business with the attorneys and we know they're waiting and we will let them in. Because when that communication hasn't happened, sometimes the same thing is the parties will call my secretary, we're in the waiting room, no one's letting us in, and they should understand, at least that's how I do it. I always start with an attorneys only conference, as I would do if we were in court with a hearing. I would just let the attorneys in the courtroom. So it's the same thing.
Yep. This one we've talked about, again, really try to make sure you have enough bandwidth. This morning I had oral argument on cases, and I had on 2 cases. One, an attorney just started glitching in the middle of his argument and we had to kind of piece it back together. In another one, the attorney that was watching, waiting for his turn, left the room. It like lost the connection, left the room. So then when he came back, we had to sort of say, well, do you want us to kind of reiterate or read back what you meant? And it was, I mean, we got through it, but really try to avoid that.
Again, this one is for the court reporter. Make sure that your name appears under your image, and make sure that your name is appropriate for, especially with your clients. Make sure that their screen name is an appropriate name for the court, because we've had some instances where it's just not appropriate. Some pretty unsavory screen names. That's the only way to put it. I think there is maybe someone who has a question. To what extent, this is from Jeffrey Greenbaum, to what extent should clients be responsible for attorney fees due to technology issues? Wow, that's a question. I don't know how to answer that. I would just suggest that attorneys are, have to have technology anyway. You have to have internet now to function as an attorney. I'm not sure how much the additional cost would be. So I'm not sure how to answer that. What do you think, Judge Nowak?
I think the question isn't so much, is this a business expense versus a client expense on a given case? I think, upgrading my technology, I think that's part of it. It's like buying pens and paper now. But I think that the question really goes to, I'm ready for a hearing. I've prepared. I've done everything as an attorney that I need to do. I'm now ready to proceed. The client then can't participate by technology. Either my client or maybe even the client on the other side, an individual on the other side, should they be responsible to pay the attorney's fees? And I think it's a good argument that yes, I think you can certainly make the claim and say, look, it's just like any other case. You've wasted my time. You've caused my client this expense, or you've caused me this expense. And I think you need to be on the hook for it. I don't know if an attorney wants to bring a claim against their own client. I think that would happen only if the relationship already fractured. But I think it's viable. I think anytime somebody wastes your time, especially if there's adequate notice in advance saying, listen, you need this, this, and this, a camera, microphone, et cetera, to appear at a conference. Don't come in saying that, oh, I don't have it working. I think that, you want to prepare as best you can to set that up if that's something you think you might be seeking.
And Jeffrey Greenbaum added, for example, if a Zoom is malfunctioning, sorry, it's jumping ahead here.
Yeah, opposing attorney, Zoom or client. I think maybe. I mean, it's tough to sort of look at why the problem occurred. I think as a judge, I would look at, if I'm faced with a claim for attorney's fees, I would try to ascertain, how did the problem occur? Was it inadequate preparation for one side, or was it just something really unanticipated? And that would probably guide which way I would decide.
And I would have to suggest that if it's something that is not one person's fault, it's not that someone doesn't have the appropriate internet, but Zoom was down for the day, or kept having problems. I don't know that that's something that you can pass on to the client. It's certainly a discussion for the client. I don't think there's an easy answer to that. There's also a question here from Kevin. Have we, Judge Nowak or I, had to deal with the issue of proper lawyerly attire in a virtual conference? Well, certainly I have. Have you, Judge Nowak?
No, I haven't. I've said people often come on without a tie. And they say, Judge, they usually apologize. They, Judge, I'm sorry, I wasn't prepared. I didn't have a tie today or something like that. And my usual response is, I'm just happy you have your shirt on. But it's you know, that's the only thing that I've seen. I haven't seen, you know, somebody in their PJs yet.
I had an emergency custody hearing that, you know, it was an order to show cause and it had to be heard within like 36 hours. And the attorney for opposing, you know, the opposing counsel was on vacation in Florida with his family. And he appeared on the last day of his vacation in a muscle shirt. Now, certainly he didn't anticipate having to appear because it was an order to show cause. But he did appear in a muscle shirt, which I think, you know, throughout the day, he then put on a t-shirt, which I thought was a better choice. But yes, it has come up for sure. Okay, next. Ooh, sorry, we
had a few more if we can go
Yes,
back to it.
we did. Let me go back.
The last one I think I've already addressed, number 5, turn off your camera and microphone until your case is called. Notify that, oh, this is a good one, number 6. Yeah, know who's supposed to be there, because a lot of times, especially if we have cases with multiple parties, I may call a case, I've got the motion papers in front of me with, you know, tabs and highlights, questions I may have for the attorneys at oral argument, and I look up and there's 2 or 3 people in the room and we begin, and you may find that one of the opposing counsel isn't in the room. I want you to interrupt me and say, wait a second, we're waiting for so-and-so, because it's very easy for me to say, oh, all right, I'm going to go to the next case. Call them, text them, email them, send them the link that you use to get on here, make sure that we're all set. We'll recall the case in just a minute, which is what we would do live in the courtroom. So try to, if you don't mind, take on that additional burden for the court to let us know. I've had cases where I've had one side do a complete oral argument, and then I'd say, okay, and you know, where's opposing counsel? And now suddenly they're not there, and we have to kind of adjourn it or something else. So please do that. Judge Martocci, have you seen that yet? Maybe not so much if you're doing individual arguments.
No, I mean, people who get hung up on a prior proceeding, you know, they're not there. And so it's very helpful, as you just said, please help us. Text people, hey, we're all ready, we're waiting for you, or email them or call them. I mean, I will say, I think everybody has shared the burden, at least in my experiences. Lawyers are pitching in, they're all really cognizant of who else is supposed to be there, and they help get the other people there. You know, there's nothing worse than having a case with, you know, lots of different lawyers, and we're all waiting for one person to show up, because nothing really can be done until the other attorney gets there. And then the last point that we wanted to make was that it's really helpful if there are papers that are on NYSEF, pleadings or whatever, and you're going to be talking about them, share them on the screen. It's helpful for us to be able to see what you're referring to.
Yeah, for hearings, I generally will make everyone who's in the room a presenter, which is easy to do. I mean, real quick on Microsoft Teams to make people presenters, and then they can share documents and pull them up and show them to witnesses. It's really helpful for hearings, but I would do it for even oral argument. If you said, gee, there's an exhibit or language in a contract or a photograph or something that you want to show on the screen to enhance the argument, think about doing that now. I mean, that's a nice opportunity. It's something that you may have done in the courtroom live if you had that chance to show a photograph or hand something up to the court. So use that feature. I love it when attorneys, you know, ask to be, if they could share something. I think it's great.
We also have another question from Hope J. Do you anticipate that judges will be expecting lawyers to return to the courtroom as a matter of course for motions and hearings now that Omicron has somewhat subsided? I'll let you start with that one, Judge Nowak.
I think no for motions and yes for hearings, I think will be the way that it goes, because having the witness dynamic is something unique. Although having a virtual witness on Zoom is in some ways a little bit better. We'll get to that, I think, in a little bit with another slide we have. But motions, I think motions are going to be like conferences. I think that the remote appearances are sort of here to stay now because of all the great time saving that we have on the attorney side, you know, the parking and the coming up upstairs and everything. So I think the remote proceedings are going to be here for a while.
I agree. And I also think that some hearings, depending on how involved they are, how document intensive they are. I think that I will continue to do some hearings virtually. The preference, I think, from most attorneys is to do things in person. But I think it's a case-by-case basis. I don't think that there is going to be one flat rule telling us that we have to do this or we have to do that. I think it's going to continue to be somewhat of a hybrid.
I had a 6-day trial that's still ongoing, but we had 6 days of testimony, and we were using the virtual evidence courtroom, and we had, 150 documents loaded, and everybody was a presenter, and we were going back and forth and bouncing, document 135, then back to document 26, then up to 180, and and it was great. And for the 6-day trial, it was like seamless, and it got to the point it was faster than if we were in the courtroom and you'd have to walk over to the table and get the paper document. I mean, we were almost getting more efficient on that. So yesterday I had a matrimonial hearing, 1 day only. And I started by explaining how great the virtual evidence courtroom is and how easy it is. And that case had like 130 documents. And immediately we started going into it, and the virtual evidence courtroom crashed for one of the attorneys. Then it crashed for me. No one was able to get any of the documents. So it's like, and it was just after I said how fabulous it is. Of course, it doesn't work. So we all have to kind of be patient, but when it works, it's great. We just have to, I think as time goes on, as that tool becomes more and more useful, we'll have more and more remote hearings because it'll again be so easy. Agreed.
When it's working, the virtual evidence room is quite impressive and easy to use. Okay, so now we've got another video we want to share. And this begs the question that all of us ask when we're doing a virtual hearing. I think this was actually a preliminary hearing in a criminal case. And so you want to know who else is with the litigant. Is there someone else in the room? Where is this person appearing from? This goes to some of the things that Liz was talking about during her presentation. So I'm going to play it.
Video of a Zoom court hearing in the small Michigan town of Sturgis near the Indiana border has gone viral, all because of one thing noticed by an eagle-eyed prosecutor.
Kobe Harris is accused of assaulting his girlfriend in her home, and when both of them appeared in the hearing remotely, the attorney, Deborah Davis, knew something wasn't right. Let's bring in Victor Williams, and he picks up the story from there. Victor.
Yes, well, this young man had a no-contact order, and he was supposed to stay away from the woman, but it had to be court of all places that they found out he was doing the exact opposite. Kobe Harris of Sturgis is out on bond and in a virtual court hearing with his girlfriend. We're not showing her face because she could be a victim of abuse, but at some point she starts to hesitate when being questioned by the assistant district attorney.
What were you and Kobe arguing about, if you remember?
Assistant DA Deborah Davis notices she's constantly looking off screen and speaks up.
It was just that we weren't, I had said I wasn't going to come back to the apartment, so he was there, and so then, that kind of initially just had started the argument.
Your Honor, I have reason to believe that the defendant is in the same apartment as the complaining witness right now, and I'm extremely scared for her safety.
Judge Jeffrey Middleton then asked for Harris's location, in which he's given a fake address.
I want you to walk out to the front of the house, show me the house number on the house.
Why? I don't even think this phone has the charge for that, sir. I'm at like 2% right now.
After a few more excuses, the assistant DA suddenly has some news.
The police are at his apartment right now, knocking on the door.
As police enter the home, the girlfriend's camera goes blank. Eventually, Kobe gets up, and then his camera also goes off. Moments pass as his attorney looks on in disbelief.
This is a issue we didn't have when we had live court.
Then out of the blue, the girlfriend's screen reappears with Kobe in front of the camera.
Yes. Your Honor, me and both don't want the no contact. I asked that that be dropped. I'm sorry I lied to you.
You can see the clear frustration coming from the assistant DA, and Judge Middleton immediately shuts Harris down.
Take the cigarette out of your mouth. The hearing is adjourned.
And of course, police wanted to make sure that the girlfriend was fine.
Okay, so I think we've got the point on that one. I will tell you that I was doing a virtual mental hygiene hearing, and the point of the mental hygiene hearing is to see if there is enough of a basis, a medical basis, to continue to have someone either receive treatment or stay in an inpatient facility over his or her objection. And so a physician was testifying at the direction of the Assistant Attorney General, and you could see the physician's eyes were reading, going back and forth as if reading a teleprompter. Well, she was reading her records, which happened to be on her computer. There certainly wouldn't have been anything wrong with her reading those records if we were in a virtual, if we were in a live appearance. She would have just said, I need to, I can't remember how to answer this question, or I need to look at my records, and they would have been identified and everyone would have known, a record would have been made as to what she was looking at. But she did it, sort of resorted to self-help, which really doesn't seem like there's anything wrong with that. She certainly didn't think she was doing anything inappropriate or breaking protocol. But in the virtual context, we just need to be really astute about what else is going on. What do we see? Who else is in the room? Are there notes being passed? Is someone texting? Again, these were some of the things that Liz was talking about earlier. Judge Nowak, anything to add on that one?
No, I think that the whole idea of coaching witnesses is something that has come up repeatedly, and we find that in the few cases that we've had about, whether we should do a remote hearing in a particular case. That's the issue that I think the court struggles with the most, because if the witness is on the stand, you know exactly what papers the witness is looking at. If the witness has their phone out. They used to take the phones away. They don't anymore, but you could certainly see if somebody is receiving a text message if they're sitting next to you in the courtroom. Not so if they're at home and they're on their computer, and they glance down for a second. You can't see what they're looking at if they're being coached or if something's happening. So, I think it's just something to really be watchful of. We had the extreme case on the video with the DV case and the person with an order of protection, but even in a simple case where a witness is looking down at notes or papers or something like that, you want to be just aware of it as much as you can. It's come up for a lot of hearings that I've had.
All right. Okay. On hearings, go ahead, Judge Nowak.
Yeah, in this case, this is a Kings County Supreme Court case. It's cited often as to the basis for why the court can order a hearing to be remote. That the court has the power to do that under the judiciary law. It's a really common site. So if you're thinking to yourself, you really don't want to have a remote proceeding or a remote hearing on a given case, I would consult this case first, CCVAR, just to see what the authority is, because it's going to be tough to sort of overcome that. And I'll let you go on to the next case. Another one that cited, this Bonilla v. State, same type of thing. In this case, focused primarily, right when the pandemic was at its height. It's a court of claims case, and the court noted this Hobson's choice during the pandemic of whether, you do an in-person trial and you expose everybody to the virus, or you have this great delay where you're putting everything off. And they said, well, the way out of the dilemma is, of course, the virtual proceeding. So that's what, that's the impetus during the pandemic. But I think the CC versus AR case is going to apply even if once we're out of the pandemic. Getting back to sort of Hope J's question about, is this going to continue? The authority is there for this to continue even absent the pandemic. The other thing I'll point out, for Bonilla v. State, when they were talking about sort of the pros and cons, and it wasn't just the coaching witness thing, it was, what about the technical delays, the glitches, all the stuff that we've sort of mentioned already. I thought the one quote by the judge in the decision, if worse comes to worse and the virtual trial is disrupted, so what? It's so much better to have a disrupted trial, a 15, 20-minute delay to fix a technology issue than it is to delay the trial indefinitely until it's safe to do a live proceeding again. I also thought, and this is the point I mentioned earlier, this whole idea of the witness, the virtual image of the witness, the court noting improvements in the technology facilitate transmission of virtual images that are clear and close up and allow for sufficient consideration of a witness's demeanor. when I've had hearings and the technology is working well, and I'm looking at the witness's face, I have a much better view virtually than I do in the courtroom, because the courtroom, I just have their profile. They're in my courtroom to the left of me. So it's actually almost better to take note of demeanor and sort of, reactions to questions remotely than you can live. It was funny when I watched the video a moment ago of the guy who was in the same room with his I think former girlfriend on the DV case, and the judge says, "I want you to go outside and take a picture of the house number," which was clever. The guy said, "Why?" And then he started to give an excuse. And I was thinking, you had me at why? Because as soon as this is the way he reacted to it, we all know, all of us knew that he was lying immediately, and that he's in the same room. So it's like that kind of thing that you can see, that hesitation, that, it matters sometimes. And sometimes that's the kind of thing where you can say, in the decision, I found this part not credible because of, something that you saw. Judge Martocci?
Yes, I agree with you. That the snippet that we saw before is rich with all sorts of things that happened in the virtual context. The guy then starts smoking a cigarette, as if he would do that in court. Let me just ask, how are we on time? Because we do have a number of maybe 8 or so slides left. Sarah, how are we?
You have about, I would say 10 to 12 more minutes, just so if there's any last questions, attendees can get those in.
Perfect. Okay, so the other thing that we've included here in these PowerPoint slides and as part of the materials we shared are the protocols and procedures for New York virtual bench trials. And so one thing to remember, these are still formal proceedings. Evidentiary rules apply. Principles that guide in-person courtroom trials remain applicable. And as we've talked ad nauseum today, courtesy of Kevin and Liz, disciplinary rules and requirements remain in place, including rules of civility. And again, all participants need to have proper attire. I had one lawyer who appeared from her bed. Now this was, early on in the proceeding, but that was just, obviously not appropriate. Again, especially as these are becoming more and more common and there's no end in sight, you have to act as if you're in court. Judge Nowak?
Yeah, I'm not put off by, having a coffee cup and having a sip of coffee in the middle of a proceeding, especially if it's a long, like all day kind of hearing type of thing. That doesn't bother me at all. Eating is obviously a problem. Chewing gum, even like mints or, throat lozenges can be distracting because it affects sort of how you're conveying things. I've sat in other hearings where a judge will get a little bit bent out of shape by somebody drinking a bottle of water. So some judges are really particular about this. I'd be a little careful. And I would even, if you have a prolonged hearing and you're like, gee, I'm going to need to have a sip of water, I might even ask permission from the court, which you're going to get. I mean, but then at least you're not, you're not tweaking the judge in some way that you don't know that you are.
We've already talked about this. Attorneys, witnesses, participants need to have their video on and their audio on only when they're speaking, but it needs to be operational. You should appear from quiet and appropriate locations. Use best efforts to eliminate distractions, whether that means turning off your phone so that your cell phone doesn't ring. And this is a protocol that, as you can tell, I'm actually not abiding by. I have a blurred background on today, but really the rules require that you have your actual background on so that you can't appear, I don't know, as if you're in an office, but you're really on the beach.
Right. The next group, I think, are ones that we've sort of covered, but we'll just remind they're part of the protocols and procedures. Only one person speaking at a time, no colloquies between counsel. I haven't noticed really an uptick in that with remote proceedings. It seems kind of, we get that in the courtroom too, where sometimes an attorney will turn to the other one and I'll usually interrupt and say, try to keep it keep your comments to the bench kind of thing. But that's just a reminder. The mute function also on the microphone, certainly for clients, participants that are watching for oral argument, they have to be muted. I've had interruptions from that in the past. I like all objections made audibly, and so I even allow opposing counsel that's not conducting an examination, keep your microphone on so that you can just say objection immediately. You don't have to unmute and say objection, which of course gives the witness an opportunity to answer a little bit. Some judges, I think, like the whole raising hand feature. I feel like I miss it a lot. Judge Martocci, do you like that?
No, I feel like I miss it a lot. Because I don't know if you have, but I have two screens. Right. So I'm looking at one screen and I'm not necessarily looking at the hand screen. I'm looking at the screen where the witness who's speaking is on my screen.
Yeah, we have a question from Kevin Sapansky again. Have you found virtual appearances create particular civility issues like interrupting adversary or the court speaking informally? Interruptions, definitely. We get more interruptions now because you're not focused on the person who's talking. And this is especially true if somebody doesn't have a camera because you don't know when they're finished. And, so that's definitely been more of an issue. Not so much speaking informally for me. Judge Martocci?
No, I wouldn't say that it's speaking informally. I do think that it's harder sometimes when you have a very contentious matter. I do think it can be harder to control the courtroom. Having been in Buffalo City Court, both of us were, in domestic violence cases are really tough things that very contentious matters in front of you. You can control a courtroom when you're sitting there looking at people. Your courtroom deputy is right there. In some ways, it's easier to do it in person in those really contentious matters. So again, going back to the protocols which have been provided to you, remember that it is part of the rules that counsel can request time to consult with his or her client. That should be talked about at the outset of every hearing or trial.
Yeah, that's an important one to keep in mind. I had the case that I had yesterday, we had a situation come up where the person that was testifying passed a note to her attorney. And it was right in the middle of and it was almost like a reminder, ask me about this or something else that was on the note. And the attorney that was watching it, that was objected and jumped in and said, she just passed a note. You can't do that in the courtroom. And she's right. It was valid. You can't pass a note. But really what the attorney and the client didn't appreciate is they could say, Your Honor, could I have just a minute to speak to my client about something? And where we were in the hearing, it was okay. Sometimes you'd say, no, answer the question first, and then you will take a break. But know that option's available.
And Judge Nowak talked about this, if the client and counsel are in different locations, you can permit the use of the breakout room. I too have had difficulty with the Teams breakout room. I sometimes will just allow people to use their own cell phones, to mute themselves on the appearance and talk to one another on their cell phones.
Yeah.
Go ahead.
This last comment again is just, be aware that there can be ex parte communications on breaks. I've had many situations where we take a break and the attorney and the client will get up from the room, but they leave their cameras on and the microphones on and they're talking and you can hear them. You can hear the attorney and the client talking to each other and sometimes saying disparaging things about the other side. I usually will mute them myself before they start saying disparaging things about me, but that's quick. You have to be fast because they do that. So you just watch that. Make sure you mute, make sure you turn off cameras during breaks. The last few slides that we included concern, and really the heading says it all, be aware of the court's limitations and procedural requests. There's an interesting case in family court out of Bronx County, SN versus JA, and it was affirmed, and the name on the affirming decision is a little bit different, so affirmed sub nom. But SN versus LA, or JA, I apologize, is the case really that you'll want to read, the 71 miscellaneous 3rd 1206A, because that's a longer decision. It talks about everything that this judge went through for this virtual trial. The court notes right at the outset, there's only 3 virtual courtrooms in Bronx County that were staffed with court reporters that were available for trial. So you knew where this is going already, where the court already had a limitation. And the judge had reserved one of these very precious virtual courtrooms in Bronx County for 2 days. And so what the judge said is set up all these procedures as to how we're going to get this hearing done in 2 days. We're going to have first all the direct testimony is going to be by affidavit. So we're going to start immediately with cross-examination, get right into the heart of the issues. And the judge was intent on getting this done efficiently and well, but it seemed like the attorneys were not on the same page at all. So the attorneys didn't submit their statements of undisputed facts as they were required. They didn't contact the court in advance to address objections. So they come into the hearing and they're basically trying it as though it's a regular live proceeding, which I think the judge anticipated was going to take 4, 5, 6 days. And I only reserved this virtual courtroom for 2 days. So they started going bad. And you can kind of read all of the things that happened. And the judge gave a warning about this, a warning about that. There's a lot of testimony from the trial included in the decision. And the judge noted all of the problems that we had. At one point wrote, stunningly, in the face of a tremendous time crunch, counsel for the father responded stating he wanted to make an opening statement. And the judge opening statements were not even having direct testimony. So there was a great deal of frustration by the court, and the court kind of went overboard as to all of these problems. So anyway, the judge ultimately decides on a custody issue after these 2 days of like piecemeal, lots of argument, kind of fractured hearing. And inevitably, as you'd expect, it goes up on appeal. Well, if we go to the next slide, the appellate court just affirms and backs up the judge completely and says attorneys for both the mother and father were strongly admonished, and they talk about the rules of professional conduct that were violated, unprofessional behavior, and the judge ended up getting affirmed. So if you're going to walk into a situation like this where the judge has set time requirements and guidelines, especially for a virtual proceeding, know what you're getting into, because you may not have, a remedy on the backside where you say, oh, gee, this judge is out of control. We're not having our day in court. You might not get it. So, you got to certainly abide by the new rules. Okay. Any questions about that case or anything else?
Just because I see that the time is coming close, and I wanted to give the last CLE code, and then we'll open it up to any other questions for those who want to ask the justices more questions. The last CLE code to get your CLE certification is court. The last CLE code is court. This will be placed in the chat. Again, please remember to fill out your CLE affirmation form and the evaluation form to ensure that you receive CLE credits and your CLE certification. If you have any additional questions for the justices, feel free to go ahead. Okay, so it seems as if there aren't any additional questions. I'm just going to briefly turn it over to Ms. Washington Sarah to wrap us up for today.
Thank you, Carisha. I posted in the chat a link to access the evaluation form so you can evaluate today's presenters, as well as the affirmation form for you to get the CLE credit. You will need to put in the codes that we provided. Again, if you missed them, they're in the chat. So before you log out of the Zoom, make sure to write those down. If for whatever reason you need them later, contact us and we know who is here. Our time has obviously now expired. I would like to once again thank all of today's speakers for their time and their insights. It was a long session, but I think we learned a lot today. You will be receiving more information about our future CLEs with our next 1-hour CLE to be held on March 10th. Everyone, please be sure to send in, I already said this, again, just make sure you send in your attorney verification form. That's the only way we can give you credit. And that's all I have. Thank you, everyone. I hope everyone has a wonderful afternoon. Be safe. Bye-bye.
Thank you, everyone. Thank you again to our wonderful speakers. Have a good day.